Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 3rd, 2026. Here's the order for the bills this afternoon. I have SB 314, then SB 358, Senator Hershey, SB 258, Senator Attar, SB 332, Senator Kramer, SB 277, Senator West, SB 319, Senator Muse, SB 353, Senator Charles, SB 259, Senator Jackson, SB 269, Senator Henson, SB 274, Senator Sidnor, SB 322 from Senator Sidnor, and then the last bill of today is SB 295, Senator Love. So I will go first. We've got a long afternoon ahead of us. Senator Charles, you want to come up for a sec?
Second chairing.
All right, thank you, Mr. Chair. This should go quickly. Many of us served with the illustrious former Senator Jamie Raskin, now a congressman in the United States House of Representatives. This is an unfortunate thing. Even really good, non-controversial bills at the federal level cannot move forward because of the dysfunction in Washington. And so when I saw that Congressman Raskin had a bill that legalized the donation of unused pet food, I thought, well, maybe we can do that here in Maryland, even as the federal government continues to debate the bill and try to move it forward. And so that's the bill in front of you. That's SB 314. Under current law in Maryland, there's obviously an entire scheme by which you can donate unused food for human consumption, and that happens every day. But there is no analogous structure for the donation of unused pet food. And so we took existing law as it applies to food for human consumption, and we applied it to pet food. And that's what you have in front of you with Senate Bill 314. With that, I'll ask for a favorable report and turn it over to my witnesses. I think we take in-person witnesses first.
Good afternoon, esteemed JPR Committee. My name is Stacy Volodin, and I am the Maryland State Director for Humane World for Animals, formerly known as the Humane Society of the United States. I am here representing our supporters across the state, as well as Maryland Votes for Animals and PAWS, the Professional Animal Workers Society of Maryland, the state's organization of animal control agencies and humane societies. Together, we all urge a favorable vote for SB 314. The Maryland shelters are currently facing a serious and sustained issue based on the rising costs of care for the animals, increases in pet relinquishment, and capacity challenges. At the same time, retailers are discarding what is estimated to be over 1 million pounds of pet food per year. The only thing standing in the way of this surplus, this problem, is the fear of liability. SB 314 is simple. It reflects the human standard for the donations and removes this barrier to the generosity that Maryland businesses want to participate in with the donation of pet foods. The impact should be immediate. Shelters would be able to redirect the scarce resources that they have and put those into things like the veterinary care and staffing of the shelters. Just as importantly, as many of you may have seen, Maryland shelters do typically operate pet pantries. So the food that's donated can also go directly to the community through these pantries. Currently, their shelves are often completely empty. And if you see them on social media, you'll notice they are consistently asking for donations of food. When these pantries are stocked, families are able to keep their animals instead of turning them over to the shelter. We are seeing relinquishment due to the cost of food. So with this bill, you're essentially saving the state some funds because these are government shelters. So with that, I urge a favorable report, as does Maryland Votes for Animals and the Professional Animal Workers Society of Maryland.
Thank you, ma'am. We're now going to bring in Ms. Sally Tom, who's also on the panel.
Yes, hello. Good afternoon. I'm Sally Tom. I live in Silver Spring and I work in a big box pet supply store. Several years ago, I asked our store manager why we threw out so many bags and cans of dog and cat food in the trash every day. And he said, liability. The company is afraid a shelter or rescue group would sue if food donated by the company caused an animal to become sick. So I took this problem to Representative Raskin, and he wrote the federal bill that you've heard about today. In short, lack of protection against an extremely unlikely hypothetical lawsuit leads to actual, real, tremendous waste. 4 facts support passage of this bill. 1, as you've heard, 30 years ago, the Bill Emerson Good Samaritan Act solved this problem at the federal level for restaurants and other retailers that donate food to organizations that feed people. We've done it for people, let's do it for animals. 2, huge amounts of edible, safe pet food end up in landfills every year. Some of it is expired, but as you probably know, most of it is always safe to eat. A subsequent manager at our store guesstimated that our store alone throws out an average of 50 pounds of kibble, dry dog food and cat food, per day. The math is easy. 50 pounds per day times 365 days a year times 3,000 stores nationwide is 54,750,000 pounds of kibble. This food belongs in the hands of shelters and rescue groups in the tummies of homeless animals and not in landfills. And 3, unlike with human food, we're also including other kinds of pet supplies. Anything a store sells can and does end up in landfills, and this is shocking and appalling. 4 animal shelters and rescue groups desperately, urgently need donations of retailers' food and supplies in order to spend their limited funds on services and goods that are not donated. Thank you for your time, and I urge you to pass this bill.
Thank you, Mr. Chair. I noticed that the Maryland Association of Justice has lodged information, and they're concerned about the fact that immunity will be granted here from liability. So I think I should ask the question: if somebody donates pet food and they know that the food is adulterated, that they would not be immune from liability for that, for knowingly passing along adulterated food, correct?
That's correct. Yep. So I appreciate MAJ's concerns. They're good folks, and they oppose any immunity, any form of immunity as a consistent ideological position. I respect that. This mimics the human food, as we indicated, which sets a standard of gross negligence. So if you willfully, knowingly, maliciously donate pet food that is bad, you are not provided any protection under this bill because you are grossly negligent in doing so.
Thank you for your answer.
Thank you.
Thanks. Where did this bill come from? I'm sorry. Where did this bill come from? What was the genesis of the bill?
Oh, thank you for asking. So Senator Raskin is Congressman, now Congressman Raskin, I apologize, filed this at the federal level. And we were talking a little earlier, because of the dysfunction at the federal level, even non-controversial bills can no longer move in the Congress of the United States. And so we thought perhaps we could take it here to the state level and pass it here and inspire other states to do the same.
Further questions from the committee? All right, seeing none, thank you very much. Thank you. All right, with that, that'll conclude the hearing for Senate Bill 314. We'll now move on. Senator Hershey is here with Senate Bill 358. Senator Hershey, welcome. Do you want to bring up your panel? I see Mr. Boreano is signed up, and then Lynn Knight is signed up as well.
Judge Lynn Knight.
There you go. Your Honor.
Thank you very much, Mr. Chairman, members of the committee. For the record, Senator Steve Hershey to present Senate Bill 358, which is a local bill that would increase the number of resident judges serving the circuit court for Queen Anne's County from 1 judge to 2 judges. Queen Anne's County continues to be one of the fastest growing jurisdictions on the Eastern Shore. With that growth has come some significant increase in the volume complexity of matters before the circuit court. The need for a second circuit court judge was recognized in 2016 when the Administrative Office for the Courts provided a letter to support the Queen Anne's County Commissioners regarding the construction of a new courthouse. And just a few years ago, we did open that new courthouse, and guess what? It has 2 courtrooms in it, but we only have 1 judge. So we are just trying to get back to what was established in 2016 and ask for that Second Circuit Court judge. I do recognize that there was a letter from the judiciary in opposition to this. And again, Mr. Chairman, we had this bill before you last year. We had the same concern that they want to wait upon a model being developed by the National Center for State Courts in making a determination on whether this judge is necessary. While we respect the process, we also understand that that would not allow us to have a new judge until 2028 at the earliest. So again, we are bringing this before you. We also understand that there is another bill that they are supporting for a new judge in St. Mary's County. We have not been able to get them to add us to that bill, but we certainly would like to use that as a vehicle if that decides to move forward. But again, want to recognize that while I'm not speaking against another county, I can assure you that we have a courtroom that is ready to go right now as soon as we could get a judge. So with that, Mr. Chairman, I'll let you also know that this bill has support from the Queen Anne's County Commissioners, the President of the Queen Anne's County Bar Association, the Queen Anne's County Clerk of the Courts, and the State's Attorney for Queen Anne's County, which I would urge you to read his testimony. The State's Attorney, Lance Richardson, could not be here today, but is very compelling, explanation on why he, as the prosecutor, feels that another judge would be necessary. So with that, Mr. Chairman, I would ask if there are any questions to let me know. Otherwise, I ask for your support of this bill. Thank you.
Good afternoon, Chairman, Vice Chairman, members of the committee. My name is Judge Lynn Knight. I am the sitting circuit court judge. I've been there since 2020. And I have 1 judge and 1 magistrate in our county. We are a growing county. There's lots of growth. As you come over the Bay Bridge, you can see it when you drive down there. And we get a lot of cases from those people driving over that bridge, and they end up in my courtroom. Our courthouse, as you have heard, was opened in 2019. We have 2 courtrooms for the judge. We also have a courtroom for the magistrate, and then we have a small courtroom that is used for settlement conferences. So they built this building to look towards the future on what this county was going to need, and that was the need that was identified in 2016. That need has only grown since 2016, and it is time for us to be able to get a judge. I have all kinds of statistics if anybody wants to ask about statistics, but that doesn't really tell you what happens inside of a courthouse. Every circuit court is run differently. Every circuit administrative judge does their work differently, but it is the amount of cases does not allow people, the citizens who are coming before me, to have their time in court, and that is just not fair. So when you see our county commissioners are all on board for the financial obligation that they have to make to be able to increase my staff, the sheriff's staff, and the state's attorney's staff to handle this, everybody's ready to go. We just need this bill to get through. So I urge you to support House Bill 358, and if you have any questions, I will step down.
Good afternoon, Mr. Chairman and members of the committee. For the record, Bruce Periano. I'm here on behalf of the county commissioners of Queen Anne's County in very, very strong support of this legislation. We had a hearing on this bill last year, and it was a very strong, very positive hearing where we really justified by facts and realities the terrible need now for another circuit court judge in the county. And it's very frustrating and very puzzling that the administrative office of the courts is opposing this. First, let me say on behalf of the county, as Judge Knight indicated, The county commissioners have the money and are willing to spend the money for the costs and expenses of what are required locally for the additional judge. But let's go back, as Senator Hershey said and the judge said, back to 2014, when we asked for another judge, and they said, well, we would approve, and statistically, it's right for you to have another judge, but you don't have a courthouse. So they built a whole new courthouse. My clients, the county. And as the judge indicated, there are 2 courtrooms there. We did exactly what was told. And now the administrative office is coming back and saying, no, we don't support your effort to have it. I mean, it's mashugana. As we say, it just doesn't make any sense. It really doesn't. They first tell you, you build a courthouse, and, because you warrant having another judge, it's done, and they oppose it. And let me just say, and I know my time is running, but let me just say, it's even further frustrating, as Senator Hershey indicated, and I say this all very respectfully, Senator Hershey indicated that the administrative office that's opposing our bill, they put in their own bill in the House side, it's not course filed, House Bill 498, where they're asking for another judge in St. Mary's County and elsewhere. And there's no opposition to that. But in reality, if I may just take another moment, what's going on in St. Mary's County, warranting there to be another circuit court judge, is happening in Queen Anne's County. What's going on administratively in St. Mary's County is that the policies of the state's attorney's office are very hard and very rigid. And I'm not questioning them, I'm not evaluating them, but it is causing a great deal of caseloads going into the circuit court. What you have in Queen Anne's County, as Lance Richardson, the state's attorney, indicated, as Senator Hershey indicated in his letter.
I guarantee you're going to get a chance to expound upon your remarks.
I'm sorry.
If the senator doesn't, I'll ask you some follow-up questions as well.
Sorry, Mr. Chairman.
No. Senator McKay.
Thank you, Mr. Chairman. Mr. Bariano, I'm confused. The Judicial Conference did recommend that you needed an additional judge. You then went ahead, the county then built the facility, and now we're saying no.
Yeah.
So I'm confused. Like in Washington County, where we went through that whole process. They're in the process of building that. In Allegheny County, it was seen that we were supposed to, we could have another circuit court judge, but the county has decided that they're not ready to move forward in building it. And so I guess, why is there a difference in the process? It would seem to me that listening to the Maryland Judicial Conference terms was the best policy. What is, can you help me?
Thank you for the question, Senator. I think the answer is, at least in my opinion, is because rather than the administrative office of the Maryland courts looking at Maryland and its diversity and the unique situations in each of the counties, they're relying on a think tank down in North Carolina to have a model to fit everything. And that's just absurd. That really is. I say that very respectfully and deferentially, because it's not always the same. And this model developed, that they're utilizing to justify doesn't reflect the realities of the localities and the unique circumstances. You have, as is indicated in the state's attorney's letter here, and I'm not being rude or disrespectful, you have a personality of a district court judge that is very, very of a certain nature. And it is causing, and that judge is going to be on the bench for another 7 years, it's causing tremendous caseload coming up to the circuit court. It cannot be handled by one judge. It's just that simple. And we did, as you said in your question, we did exactly as the administrative office said, and the county at their own expense, my client built a courthouse deliberately with 2 courtrooms. And now when that's all done and we're ready and the county's willing to accept the further financial responsibilities of their part, basically at the state level, and I could be corrected on it, it's the judge's salary and the judge's law clerk.
Correct.
But the other ancillary, it's all done at the county level. And so there's not really a fiscal problem on this at all. But it really makes no sense As I said, it's Michigan. It really is. It makes no sense for them to, now that we've done what they've said, say, no, you're not worthy of it.
Well, my Yiddish is very, very limited, and I
Excuse
would
me?
say my Yiddish is very, very limited.
Well, I'll send you my glossary of all the terms, all right?
But certainly this bill, the need for it or whatever, seems to drive me mashuga. Thank you.
Thank you, Mr. Chair. I think I learned more Yiddish in the last 5 minutes than I've known before. So I love Queen Anne's County. I had a trial there many years ago. In fact, it was so long ago, it was Judge Souse was presiding judge. And had very fond recollections because I won the case. But I was in the only courtroom at the time in the old courthouse. It was really lovely, but it struck me as being antique. And maybe that's a compliment because it really was old. So I can understand why there's frustration if you build a new courthouse with 2 courtrooms on the promise that when you get the courthouse built, you'll have a second judge. Now there's no second judge. It sounds like something got lost between the cup and the lip. I guess I have to ask you just one question. You brought the bill last year. In the 12 months since you brought the bill last year, has the judiciary done anything to try to alleviate the administrative problems that exist currently in Queen Anne's County?
The other Jewish word, gunisht. Gunisht means absolutely nothing. And that's the answer, gunisht.
All right, thank you.
And that's, so, and I'll just say one last thing.
Yeah, let's say the judge, yeah, come.
I can answer that question. They have started relooking at the model. They've started a work group to look at the model to reevaluate it. The model that they used was from 2017. Well, this is 2026. That's going to take a 2-year process to be done. So they're in the process of doing that. I have access to senior judges, so they are retired judges. They've each reached the age of 70 and are still sitting, or they have retired early and are still available to sit. But you bring someone from Prince George's County, no disrespect, down to Queen Anne's County to hear a case, they don't know what services are available. They don't know how the state's attorney prosecutes cases. I love to have them there, but they just don't know Queen Anne's County. And so we have to be very particular on what we allow other judges to do because it affects our citizens. Our citizens should have someone who understands them.
Your answer is very helpful.
Typically, we try to respect separation of powers, and we dance on both sides of that line in this committee from time to time. But I just wanted, why is their assessment of your workload and needs so much? Why does it vary so much from what's actually happening or what you're testifying to? Just because my default is, we want to help. I want to help out, but I just want to understand why there's such a departure of understanding or opinion on this, or is it just the system has not gone through? They haven't gone through their process yet.
Right. If you look at their letter of non-support, it said they recognize, we have asked several years for a judge. We've been part of this process. And in fact, St. Mary's just asked last year. They don't fit the model either. So any judges that they are asking for don't fit the model. So then why are you relying on the model to ask for judges if none of what you have said fits the model? Every circuit court runs differently, and that's the tough part. You can't do apples and oranges. State's attorneys are different. Attorneys who represent OPD, Office of Public Defender, handles the majority of our criminal cases. Their office is different. Everybody's different. And so that's the part of the model that is very difficult in quantifying what a judge needs.
Sir, and then.
Just one point on the separation of powers, Mr. Chairman, and I think you all know I've been around here a long time, so at least I've had that benefit. It's been the strong prerogative and action of the legislature to create additional judgeships. And so there's no violation of separation of powers. It's within your, not only your prerogative, but respect for your duty so that the administration of justice is done properly for all the citizens, and the uniqueness of the counties are recognized. So just relying on a think tank and a model, it's just not the way to do it. And seriously, we have a very, very serious problem in Queen Anne's County that the citizens or whoever comes before court, they're not really having their day in court. Thank you very much.
No, I respect that. No question as to whether it's under our purview to do it, but just, yeah, the general principles, I try to respect that generally. Senator, if you would work with us with budget and tax, just to address some of the fiscal note, I don't think it's insurmountable, but it'll take some follow-up with both of us if we could. Be happy to do that. Excellent. Okay. Further questions from the committee? All right, thank you very much.
Thank you, Mr. Chairman.
Thank you. All right, with that, that'll conclude the hearing for Senate Bill 358. We'll now move on to Senate Bill 258. And I know we're going to be joined by Senator Attar's Chief of Staff to read in some remarks, and then we'll turn it over to the panel. Mr. Newman, go next. So welcome.
Thank you. Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. For the record, I'm Sandy Rosenbluth, Chief of Staff representing Senator Attar. Thank you for the opportunity to submit testimony in support of Senate Bill 258, Real Property Dedication Roads. Senator Attar joins with her colleagues in the 41st District in sponsoring this legislation to protect homeowners throughout the state of Maryland from losing historically and publicly provided road maintenance and paving services. This issue has become an ongoing and serious problem in our 41st District, where hundreds of constituents have had public road maintenance abruptly withdrawn from their streets, services that the City of Baltimore has provided on these same roads for more than 60 years. These residents have relied on consistent municipal maintenance and have reasonably understood that the roads to be public for decades. Historically, many of these roads were once considered private and not open to the public, and in some cases were gated by the landowner. However, over time, as additional homes were built and communities expanded, these roads became interconnected and evolved into public access roads. For decades thereafter, the city maintained these roads in the same manner as other public roads, opening them, grading them, repairing them, and funding their upkeep with public dollars. Maryland law clearly addresses this situation. Courts have recognized that a road can become public when it has been openly and continuously used by the public for an extended period of time. Courts have also determined that a municipality effectively accepts a formerly private road as public when it treats the road like other public roads by maintaining, repairing, and improving it using public resources. That is exactly what has occurred in these communities. Despite this well-established legal framework, the City of Baltimore now asserts that a local ordinance permits it to perform maintenance on private roads without formality, accepting them as public roads. The city further claims that it may withdraw this maintenance at any time and without any notice. As a result, homeowners are suddenly losing taxpayer-funded public services simply because of a change in leadership within the Municipal Department of Transportation. This position directly conflicts with longstanding Maryland court rulings and undermines the reliance interests of residents who have lived for decades on roads treated as public by their local government. An additional concern highlights the confusion and inequity these creates for homeowners. The Maryland State Highway Administration maintains an interactive map that identifies every road in the state and which entity is responsible for its maintenance. We have confirmed that this map is populated using the City of Baltimore's own GIS data. Homeowners who consult this map will find that many of the roads the city now claims are private and refuses to maintain are in fact listed as public roads for which the city bears maintenance responsibility. Furthermore, it appears that counties and municipalities across Maryland handle this issue in inconsistent ways. Some honor longstanding maintenance practices and legal precedent, while others withdraw services abruptly. This lack of uniformity results in unequal treatment of Maryland residents based solely on where they live. Senate Bill 258 is necessary to codify into state law what Maryland courts have already established, that when a road has been open to public travel for decades, and has been maintained at public expense, it must be treated as a public road. This legislation will provide clarity, protect homeowners, and ensure that all Marylanders are treated fairly and consistently under the law. For these reasons, I respectfully urge the committee to issue a favorable report on Senate Bill 258. In addition, Council Schleifer from Baltimore City submitted a letter today in support. In addition, we have drafted 2 amendments. One satisfies the concern of the Maryland Builders Association, and one satisfies the concern of the Maryland State Highway Association. And lastly, Montgomery County and Mako both were opposed to this bill. However, they've since advised us that they no longer oppose the legislation. Thank you for your consideration.
Good afternoon. Thank you, Senators, for allowing me to testify in favor of this important bill. I'm Jay Newman, President of the Poplar Hill Association, a neighborhood in North Baltimore City. Senators, I ask you to just pause for a second, please, and envision your own home in your mind. Envision your street. You've probably counted on your city or your county to maintain that street for many years. Then imagine one day learning your county or city has suddenly reclassified with no notification your road as private, and maintenance services are abruptly withdrawn. How would you feel about that if it was your home? Well, this is exactly what's happened in our community. For over 70 years, Baltimore City has maintained our roads, paving, repairing guardrails, and even handling drainage issues. Then the city abruptly stopped these services, reclassifying those same roads as private. A city official even telling homeowners that I represent, quote, "These roads are like my driveway. If you want them paved, go pay for them themselves." That's what the taxpayers of these communities in Baltimore affected were told by a city official. Now, the city claims our roads are private, but Maryland court rulings say otherwise. They say that a public road is established through long uninterrupted public use of 20-plus years, and when a municipality has maintained those roads at public expense. Now, the city will tell you, in fact, they sent you a letter, and they claim that they have a local law, and that local law trumps what the state courts have said. And they'll argue it supersedes all the state court rulings. It's not what the courts say. Different municipalities, and I'll wrap up, Senator.
Yep.
Municipalities handle this issue differently. Many adhere to the state's definition of public roads, some do not. Our request is very, very simple. Let's handle this issue and solidify into law what the courts have already ruled, so that all state residents are treated equally and fairly. Roads open to the public for 20-plus years, with cities or counties historically having maintained them, should not be exempted by
Mr.
local
Newman,
codes.
thank you very much. We have a
Thank you.
question from Senator Sidnor and from Senator West.
Is this bill supposed to be retroactive or is it prospective?
We believe that as written, although I'm sure the senator would be glad to clarify if necessary, that this would apply the same way the state court rulings are. So any road, I guess, in the past that's 20-plus years and has been maintained in the past would be constitute public roads. So in essence, it would.
So you're saying you want to be
it would be
retroactive?
retroactive, but the courts have already said that. So all we're doing is codifying that.
Any idea, and I'm speaking to Mr. Tarr's Chief of Staff, any idea outside of Baltimore City how many roads we're talking about that could possibly fall under this legislation?
The best I can say is that I will write it down and I will get back to you.
Okay, thank you.
Thank you, Mr. Chair. So, Mr. Newman, I noticed that according to the fiscal note, the dedication of a road to the public can be accomplished in various ways, and one of them is by prescriptive easement. And here's a case from the Maryland Court of Appeals, now the Supreme Court of Maryland, Mount Sinai Nursing Home versus Pleasant Manor Corporation, that held that uninterrupted use of a road by the general public for 20 years vests title by prescription as a public easement. So tell me, do you know how long this road that you're talking about in your neighborhood has been used by the general public without the city blocking it off and saying you can't use this, it's a private road?
So there are a number of roads affected, but these particular roads have had public maintenance for over 60 years.
And members, I will tell you, I have driven my car down that road. When I was back in high school in 1967, 68, I dated a girl who lived on that road. So, and nobody blocked my use of the road. So in my experience, at least, it's been a very long time that the public has been able to use that road with, as if it were a public road, correct?
That is correct. And again, I want to emphasize to the committee that we're not inventing something new here. This already exists in Maryland under common law. In fact, we were informed by the representative of Montgomery County the other day that she had consulted with the city attorney or county attorney of Montgomery, and they even confirmed that if a road is open to the public for 20-plus years and maintained as a public road, what Baltimore City and perhaps others have chosen to do is to try to circumvent that law with their own local code. Our advisors don't believe that's legal. On the other hand, my members don't have $150,000 to fight Baltimore County in court to win this. So all we're asking today is don't invent new law, just codify it and let's take care of the issue.
Well, let me pursue this just for a little bit. So do fire engines use the road you're talking about?
Fire engines, ambulance, police.
Police cars,
Yes.
trash trucks? Trash trucks?
Trash trucks, snowplows.
So the city vehicles use the road, and you say the city has been maintaining it for the past, I think you said 67 years? Okay. And then finally, I think you, in the packet that I got, there's an opposition testimony from the Montgomery County and from the Maryland Business, what's the name, MBIA. But I think you indicated in your testimony that they have withdrawn their opposition?
So we have had, over the last couple of weeks, extremely constructive and cooperative conversations with the Maryland builders who agreed not to oppose the bill, the Maryland Highway Association with an amendment that's been offered, administration, excuse me, agreed not to oppose the bill. Montgomery County, after consulting with their county attorney, agreed not to oppose the bill.
And I think you said Mako as well.
And it's not Mako, it's the
It's the Maryland Municipality League.
Yeah, okay, great.
it
Gotcha.
agreed not to oppose the bill.
Okay.
So it seems that we're down to about one municipality in the state that thinks that this is a bad idea and thinks it's okay to go to its taxpayers and after 60 years withdraw road maintenance. I want to make one other point, and I know you're pressed on time, that the senator made in the testimony that was read. The Maryland Highway Administration, if you haven't seen it, has a wonderful interactive map. And you can tilt and pan and go into that map and click on and highlight any road in the state of Maryland. If it's a private road, it is on the map, it does not light up. If it's a state road, if it's a county road, if it's a city road, you click on it, it lights up, a box comes up, and guess what? It tells you who owns the road and who's responsible for maintenance. In each one of the cases that we're aware of, including a road that we're aware of in West Townsend, which is done by Baltimore County. In every single one of those cases, the state Maryland highway map indicates those roads are owned by Baltimore City and are to be maintained by Baltimore City. Guess who populates that map? We have an email from the Chief of Staff in the Maryland Department of Transportation who confirms that the information that they got to populate that map, which you click on, which shows all these roads as public, came from GIS data provided by Baltimore City.
Great.
And now Baltimore City all of a sudden arbitrarily says, we don't want to maintain it.
Thank you very much for your testimony.
Sure, thank you.
Thank you, Mr. Chairman. Thank you for this bill. My first question is, so Baltimore City, the road in question is in Baltimore City or is in Baltimore County?
There are a number of roads in Baltimore City that are all in Baltimore City. My reference, and pardon me if I misspoke, Senator, my reference to Baltimore County is that in our informal discussions that we had, we became aware of a similar road that used to be private in Baltimore County that through this process is now considered public. So this law would not affect that law, that road in Baltimore County.
So this legislation is for roads that, I mean, I know it's statewide, but in your particular case, it's a Baltimore City road that has been maintained for more than 20 years.
Our members all live in Baltimore City,
That answers
so
that
our
question.
focus has been Baltimore City.
Okay.
We believe that this situation may exist here and there elsewhere in the state. In talking to the senator and the 3 delegates in the House, I think the feeling was, since this codifies state Court of Appeals, Special Appeals, now Maryland Supreme Court rulings, that it was best to clear this matter up once and for all statewide.
Okay. As you talk about residential roads, is that in any of your deliberations and talks, has you had any of these residential roads extend through commercially zoned parcels?
To my knowledge, all the roads in question are residential roads. Thus, if you follow the city's logic that some taxpayers get public roads and some taxpayers have to pay for the roads themselves, the cost, which is multi-millions of dollars, even for a moderate-sized road, would be astronomical for homeowners. The other point I should make, Senator, is that the normal process when somebody develops homes, like a new development or something like that, is that the developer owns the roads, and then through a process, one of 2 things usually happens. Either they're turned over to the city, or there is some kind of HOA or road maintenance association, and each of the homeowners required to chip in. These roads don't have an HOA. It doesn't exist. They're private homes. They don't have a road maintenance association because they've been maintained by the city. We're not even sure how we would go about even starting that today.
Yeah, well, to actually, there is a process that's already in for both towns, municipalities, any kind of a road that's not to the standard, either with state highway or the individual town, you can bring that to those standards and then they can adopt those roads and that type of stuff. To speak to Senator Sidnor's question about how large this is, in the rural areas where there's not been a lot of money to pay for infrastructure and those type of things, there are a lot of residential homes that do get built, and these OP roads, other people's roads, it is, through the years, gets very confusing because people who then are selling their properties, that doesn't convey that people don't understand that it's another person's road. And when that road is built at the first part, it's not for another 20 years before there's really serious issues. And so this is significant for other parts of the area and that kind of stuff. I know in Allegheny County, we have a pretty high percentage of other people's roads, and it's always back and forth between what the county and county can't do. And I also know that through this flood that Allegheny ended up having, we had an other people's road that actually had a bridge that ended up getting condemned, and that bridge goes right through a shopping center. And because of not being able to be clearly marked of who owns what, the shopping center, through this other people road that has been going through there for 70 years, they haven't been paying taxes on said bridge. No one has been paying taxes on it and that kind of stuff. So it is significant amount. So that was my question on the commercial part of it. And Senator, it is, I mean, it's going to clear some things up, but it will be significant to the county for costs. So I'm just stating that as, I believe, an obvious point. Thank you.
Thank you.
Just a point of clarification, I mean, the MML is now off of the bill. I think they're off. I received an email from them saying that they're neutral on the bill now. And there are 2 points which are just discussed with the senators, is the maintenance and the liability are the 2 points that they were concerned with. Are they off because there are forthcoming amendments, or are they off because of whatever their understanding is of the common law?
Senator, excuse me, my hearing aid is not turned up. So I did hear your question. I didn't hear which organization you were questioning.
MML, which is the Maryland Municipal League.
Yeah.
They're off the bill
mayors,
now.
yeah.
But
So-
are they off because?
Yeah.
Yeah.
There's, and my understanding is that Bill Joust, the head of it, has, I think, emailed some of the senators. We had a meeting with Delegate Rosenberg over at the House, the representative of Montgomery County, and Mr. Jost representing MMA, I guess, Monday, sorry. In that meeting, the representative of Montgomery County, who was going to oppose the bill, told us they were no longer opposing it upon advice from the Montgomery County attorney, who confirmed that state court common law already says exactly what this bill says. In terms of the other association, that apparently was news to them. They were not aware of the court rulings when they sent in the opposition. This morning, he was going to go back and talk to his members. This morning, we were informed, and I believe the committee has been informed, that they have withdrawn their opposition to the bill. So they are no longer opposed to the bill. And to answer your question more directly, they, according to what we were told this morning, are not going to file an amendment. They are taking no position on the bill.
Got it. Thank you for that. Further questions from the committee? All right, seeing none, thank you both very much. With that,
Thank you very much.
Thank you. With that, that'll conclude the hearing and the testimony for Senate Bill 258. We'll now move on to Senator Kramer with Senate Bill 332.
Good afternoon, Mr. Chair and members of the committee. Mr. Chair, I believe there are some folks who wanted to be up here as a panel. Is that okay with you?
Yes, absolutely.
All righty then. Thank you for that. Colleagues, Ben Kramer introducing Senate Bill 332, Condominium Property Insurance Deductibles Unit Owner Responsibility. Colleagues, this bill is pretty straightforward. It changes the current $10,000 to $25,000 as the maximum amount of the Council of Unit Owners Property Insurance deductible for which a unit owner is responsible if the cause of damage to the condominium property originates from a unit owner's specific unit. The need for this change is that increased expenses for repairs, replacement, and construction have grown dramatically, and the existing $10,000 limitation is woefully insufficient to cover the majority of the expenses associated with damage that can originate from an individual's unit, especially when the individual who caused that damage then doesn't have the insurance, and all of the other unit owners have to pony up to cover the cost. So at the moment, in the event that the association master policy is $25,000, and the fact of the matter is, the premiums, the lower you have your deductible, as we all know, the higher the premium. So to try to minimize policy expenses for all condo owners, the associations will have a deductible that helps balance policy cost with out-of-pocket costs should there be a loss. So $25,000 seems to be, at the moment, the sweet spot that the associations are looking to have. And the problem is that right now, under law, for individual unit owners, we require $10,000 coverage. If there's damage that exceeds that $10,000 and it doesn't hit the deductible for the building, then every one of the unit owners has to pony up the difference. And that can result in hundreds, if not thousands of dollars of assessments to individual unit owners for damage that had nothing to do with their units, and because the deductible carried by the person whose unit was the source of the damage is capped at $10,000. So the goal here is to put in place a reasonable deductible for the unit owners, and the premium for increasing from $10,000 to $25,000 for each unit owner is nominal. But if we don't have that in place and there are damages and the cap is still at the $10,000, everyone else is out of pocket a significant sum for damage that they did not cause, and the overwhelming claims for condominium property damages originate from an individual's particular unit. So this is about ensuring that the residents of the condominium units are treated fairly, paying out of pocket as little as possible for damages when they occur, and that window between individual units and the master policy carried by the building. There are going to be a couple of amendments offered. The first one is clarifying in nature. Right now, there seems to be some ambiguity as to how the claim is treated. For instance, if in fact the building with the master policy decides we've had this damage and it's $25,000, we don't want to submit a claim, so therefore, does the unit owner still have to pay the $25,000 if in fact no claim is made? And there's some question in current law as to how that is treated. The amendment would clarify that whether the claim is placed or not, if they're doing the repairs and the cost is expended for the damage, the unit owner's insurance is responsible for the amount up to the $25,000, because sometimes it's not prudent to submit the claim by the master policy because premiums may well go up as a consequence. So amendment number 1 is just to clarify that circumstance. The second amendment provides a mandate that condominium owners have, in fact, just the necessary deductible under this bill, the $25,000. And if they don't document that to the condominium association and they don't prove that they have that insurance, then if the association chooses to do so, they can bind coverage for that unit owner and then bill the premium back to the unit owner. So those are 2 amendments that will be coming forth. Finally, it is my understanding that the handsome Senator McKay is going to have a bill that has yet to get drafted, but I believe it's coming, that would adopt what this bill does and the 2 amendments that I just referred to, all in one bill that's being drafted now. So the bill I have is the underlying change from 10 to 25,000, 2 amendments being offered, put it in the same posture that Senator McKay's bill will be in. At the end of the day, my goal would be just to see that one of these 2 bills gets across the finish line so that we are doing right by our condominium unit owners and minimizing their costs at the end of the day. So with that, I thank you, Mr. Chair, Mr. Vice Chair, and colleagues.
Good afternoon, Chair Smith and members of the committee. Let the record show my name is Robin Manoogian. I am a member of the CAI Maryland Legislative Action Committee. I'm also a 32-year insurance agent, and I've specialized in community association insurance. So part of the problem with deductibles right now, I've been dealing with deductibles since 1994. They started out low and they've been increasing. The insurance industry is in peril right now, and they are simply not issuing policies any longer with a $5,000 or even a $10,000 deductible. It is very commonplace right now to see deductibles of $25,000, $50,000. I've got a community in Chevy Chase with water problems. They have a $250,000 water damage deductible. And so what ends up happening when you cannot pass through a greater amount to the unit owner in whose unit the loss originates is that you amortize that balance of the higher deductible to all of the owners. What we want to do is at least bring us up to the smallest deductible that we're seeing in the market, which is that $25,000. Then, as Senator Kramer explained, we also are looking to add 2 amendments to the bill. The first one would allow for less ambiguity when the association elects not to file a claim. And that happens often. So you've got a community that has a frequency, severity issue with their loss history. Filing more claims would simply make the procurement of insurance that much more difficult for them. They end up in what is called the E&S market. That's excess and surplus lines. Their insurance gets very, very expensive. The deductibles get even higher. Then we are also asking that we mandate carrying an HO6 policy. That is the condominium unit owner's policy, which would cover the owner's deductible responsibility. If I can make one more point, we brought this bill before this committee and before the House last year. And I think that I did a poor job of explaining that this bill will help unit owners. When you have no way of passing through greater deductible responsibility to the owner in whose unit a loss originates, The association has to foot the bill some way. They do that by raising assessments, they do special assessments, or they tap into their reserves, none of which are covered by an owner's own policy. If we simply raise that threshold and have the funding mechanism for raising the threshold to the unit owner, we have that covered, and we have really limit the out-of-pocket expense to the owner.
Excellent. Thank you. Senator James.
Yes, thank you, and thank you both. Always a pleasure to listen to your voice. I just wanted, you know what I mean? So this is not mandatory, it's discretionary. In this, the way I'm reading it is that this can be done, that we would raise the limit not to be exceeded by, but the particular condominium association would still retain some discretion as to whether they want to follow this policy. And the reason I ask is I'm from a county, Harford County, where it's just a different economic situation, different in how many condominiums, associations we have, and I think this is coming from a more affluent area and the like. So I don't always like to mandate in these community associations, which are designed to allow the community members to kind of figure out how they want to live with each other in a particular association. So am I correct that this is going to raise it but not mandate it?
You don't have to carry a $25,000. If the association can obtain insurance subject to a 5 or a 10, they can keep that.
Okay.
But this addresses if they have that higher deductible and the renewal is contingent on carrying a higher deductible.
So we have two, and then I just want to understand this problem. So you indicate there's a problem, and I know I do insurance work as a lawyer, but that insurance companies aren't writing policies frequently with these lower deductibles. You're seeing more and more of these 25, and then even, or higher, I suppose, or even, you said one has a $250,000 deductible. Now that is for a policy for the association itself, not the individual.
Correct.
Is that correct? So I'm just trying to figure out, so what this is really being driven by is not so much a lot of unit owners not being insured themselves adequately, but the problem of the associations having more and more trouble getting the right fitting policy, and thus without it, and the unit owner has appropriate insurance, but it's not the insurance that will mitigate the problem the association, the greater association is having. Is that correct?
That's right. So it's important to understand that 11-114 of the Condo Act requires that we insure the units as the developer originally conveyed them.
Mm-hmm.
So when you have a claim in the unit, the obligation for the association is to repair and replace, put the unit back exactly the way the developer conveyed it.
Mm-hmm.
If there's damage to improvements and betterments, that's what the owner has to insure under their own policy. And our goal then is to require that the owner carry their own insurance, notwithstanding what they need in terms of their own coverage, but something that will fund this higher deductible responsibility.
Okay. I'm going to have to really think about whether this is the best way to skin this cat, but I do understand the problem, and you're always so articulate that I understand it, and you were too. So I'm going to think it through, but thank you. I think that's all I had. Thank you for answering those questions.
Okay, and if you have additional questions, certainly you can get in touch with me.
Yeah, thank you.
Chair. Robin, I had some questions for you.
Okay.
But like going to AMC theaters, I get to go and see all the previews beforehand, and the good senator really gave me a great synopsis of a preview of a similar bill that's going to be coming through. But I'm just asking your opinion. He left us with a little bit of a cliffhanger.
Okay.
Of which bill to have. And if you were to make your decision of which bill this committee should pass, should they take into consideration that we have a ring and two men enter, one bill leaves, would there be a way that you might figure out an amendment that we could figure out which bill we need to pass? Do you have anything to say?
Yeah, I do. So Senator Bidel brought the current bill in front of you to Senator Kramer. We did not know that she was going to do that this year. It's a repeat of what was brought before this committee last year. Senator Bidel was once a nationwide agent, so she has had a lot of constituents reaching out, really needing help, because every time there's a higher deductible on the condo side, they're having to fund it through these special assessments, dipping into reserves, which is very dangerous, or they're simply budgeting for higher deductibles. I think that the amendments that we have proposed here in our testimony, which I think will end up on your bill, is probably the better way to go, because we've allowed room for the association to make a good business decision to not file a claim if they don't want to. And that is a lot of the problem. So what we're seeing is that the unit owner's carrier will not cover the deductible responsibility in some cases when the association doesn't file a claim. Certainly, they have the option to not file the claim if they don't want to, if it's going to only be a little bit over that deductible, or if the claim will not reach the deductible. So a lot of these HO6 carriers are saying, well, if there's no claim, there's no deductible, we're walking away. I think that what we've done here will address that ambiguity that Senator Kramer had explained, and I think if he would probably acquiesce in Thunderdome to you if you are willing to drop a new bill.
If I may, Mr. Chairman, this whole movie theme, you had me at hello, and I like your answer, so
Good.
thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. So I live in a condominium community, and our condo fees are extremely expensive. $500 a month, and it covers water. But they're considered like townhouses, and then we have condo apartment style within the neighborhood as well. And each year it seems like our condo fees just keep going up, and so a lot of my neighbors are upset. That actually is one of the reasons why I first ran to get on the board in my neighborhood when I first got introduced to politics. Is because they were going up on the condo fee when I first bought the house. And so what it looks like with this bill is it's going to add another fee on someone. For instance, in my community, we have some folks on fixed income, retired federal government workers and retired school teachers who live in my neighborhood. And this fixed income just kind of limits them. And so some of them don't have access to $10,000, let alone $25,000 in their own bank accounts for a deductible. So if somebody's house catches fire or something happens, the roof caves in, and they're responsible for paying for this, it can get extremely expensive. Let's say the work is $30,000, they're responsible for the $25,000 up front first, so the neighborhood doesn't have to take on that burden because it happened in their unit. As we go through this year, especially with affordability being one of our biggest focuses, this sounds like a bill that we're pushing the burden back on homeowners, putting them in a position where we could bankrupt some families, or like I said, or families who don't even have access to $15,000 or $25,000. Like some communities may be able to benefit from this, but what it sounds like is it may create some issues. Could you speak to that?
Yeah, and to the contrary, just to be clear, when the deductible is being raised from $10,000 to $25,000, that's on the insurance premium side. So this is not talking about association fees. This is the individual will just need to increase their deductible in their personal policy from the current $10,000 in law to $25,000 so that their insurance covers that cost. We're not asking them to pay it out of pocket. So in other words, if there's $35,000 in damages, they've got to dip into their pocket for $25,000. All we're saying is it may cost them an additional $30 or so a year in their premium to increase their deductible, but what they're doing is protecting not only themselves, but every member of the association who would be responsible for those costs if they did not increase their deductible. So the goal here is to save you and everybody else a huge out-of-pocket assessment by ensuring that everybody has in their insurance premium a deductible of $25,000 to match the master policy, because if it doesn't, that master policy, the difference has to be made up and it gets billed back directly to every member of the association, which could cost them hundreds of dollars individually, depending how big it is. It could be thousands. And so, yes, premiums may escalate minimally by increasing the deductible coverage on their insurance policy, but it saves everyone hundreds of dollars if we don't do that. Let me get, and this may just be my ignorance, and you guys You are a
can
brilliant man. I would not say that.
For premiums, right? So premiums, what you're paying every month, right? That's your every month bill. If I'm paying, my condo fee will be considered a premium, right? That's $500 a month. A part of that $500, $150 is going towards the master policy for insurance. So that, let's say it's an extra $150 out of my $500 goes toward that. That's the premium. But
no, I'm talking about your personal premium on your unit.
So we're not talking master policy.
No.
We're talking the individual.
Correct.
So for instance, take my neighborhood out. We have a master policy for the external, the roof, everything outside. Then inside, we have to have our own insurance to cover if a fire did take place. We're responsible for replacing everything inside. So by increasing or decreasing, how does that, that was gonna be my bill anyway, if I'm already covered inside.
So yes and no. If this is an aside, but if your property management company is telling you that you are responsible for repairing and replacing everything in your condominium unit, then you've been misled. So the way the Condo Act is written, if you, let's say you have a romantic dinner and you start a fire, the master policy is written to cover your unit, original grade floor, ceiling, wall coverings, cabinets, counters, appliances, fixtures, and equipment. The only thing that you are responsible for insuring is any improvements and betterments, like let's say that you want nicer cabinets and you rip out the old plywood, whatever they are, and put something nicer in. At time of loss, your policy would be triggered to cover those improvements and betterments. You are not responsible for covering anything original grade. So we don't want to take anything out of pocket to anyone. The mandate that we're requesting for an owner to carry their own HO6 policy would be to cover certain things that they should be covering anyway, but it would cover their deductible responsibility. They can do that either under their dwelling limit, you can carry $25,000, or under the loss assessment. The average HO6 policy costs an owner between $400 and $500 a year. That is a small burden to bear when you compare an out-of-pocket right now at $10,000 and then what we're proposing at $25,000.
Can I just let's cut through this? Since we're mandating this policy to go up to $25,000, how much more is the premium going to be a month for the average person?
So we've heard, and it's anecdotally, but let's say that I've got a $10,000 improvements and betterments HO6 policy. The cost to go from $10,000 to $25,000, we've heard is $8. $8.
That's what his answer.
Yeah.
Okay.
But it really is important that you have that HO6 piece, which is going to help you in any number of ways. So one thing I should point out, so the separate HO6 bill that we tried to drop last year, we met with Senator West. Senator West said, Robin, I don't care about personal liability, the personal property contents, additional living expense. What is going to cover an owner's deductible responsibility? And we pared down that bill last year. We've done that exactly item for item, what you had asked us to do last year. Just the coverages that would cover deductible responsibility is what we're mandating as part of our amendments this year, and then certainly what we would be asking Senator McKay to drop later this session.
And can I just ask just one last question? Because this was the part where I was saying maybe it's my ignorance, but about the insurance deductible, the deductible itself.
Oh, for the HO6 policy?
Well, whichever policy that says, it says the insurance deductible should not exceed $10,000, and we're going to move it up to $25,000.
That's the master policy.
Okay.
So an association, again, you have a property policy as a condominium association. And if you've got a high condo fee, it tells me that you might possibly have had frequency severity issues, and maybe your master policy is subject to a pretty high deductible as well.
So this one here says the Council of Unit Owners Property Insurance Deductible amount exceeding the $25,000 responsibility of the unit owner is a common expense.
Correct.
So that's back to the master policy again.
That's right. So if you've got a problematic association with, let's say, $100,000 deductible because they had a lot of claims, the most that an owner would be responsible for under this bill is $25,000. Anything above and beyond that would be handled as a common expense. And then it's really important to note that losses that originate outside of the units, outside of the buildings, from a common element, those are handled as a common expense. We are not trying to change current law where we would assign those types of claims deductibles to the owner.
All right, so once again, I'm gonna read this one more time because it's saying what I'm thinking it's saying. It says the owner of the unit where the cause of the damage or destruction originated. Fire happens in my house. The destruction originator is responsible for the Council of Unit Owners Property Insurance Deductible not to exceed $25,000. So if a fire happens in my house, romantic dinner fire, as you posted, happens in my house, that $25,000, I am responsible for paying. And with a deductible, when you look at what a deductible is, it's the money you have to pay out first before the insurance company spends any money. So what this does is it increases my out-of-pocket expense up front.
Not if you have an HO6 policy.
Okay.
And so that HO6 policy is the funding mechanism to cover your deductible responsibility.
Gotcha.
And then your deductible under your HO6 can be as low as $250.
All right, well, I'm good now.
Okay,
I have the
good.
answer. Thank you. Yeah.
Chair, it's nice to see you again.
It's good to see
A
you.
year later,
I'm sorry?
a year later.
Yes, yep.
So it's confusing. Let me see if I can't try to clarify the confusion. Right now, if a fire occurs in a condominium and it originates from a unit, owner, and the condominium has a deductible of $10,000. It means that all the damages in excess of the $10,000 are covered by the insurance purchased by the council of unit owners.
Correct.
And that first $10,000, either the unit owner is going to go bare and maybe have to pay the $10,000 or get his or her own insurance to cover that first $10,000.
That's correct.
And the cost of that, there would be a premium associated with that $10,000 insurance policy. If we pass this bill, it means if there's a fire that originates from a unit in the condominium and the damages exceed $25,000, the council of unit owners will have insurance that will cover all the damages over $25,000.
Correct.
And they presumably will pay a smaller premium for a $25,000 deductible than it's currently paying for a $10,000 deductible. So there'd be a, right?
So there is a savings. If the board of directors wanted to select a higher deductible to save premium, they could do that.
Yeah, let's keep it simple.
Well, but
So
the takeaway is that the industry is changing. That 10,000 is starting to go away.
I hear you.
Okay.
I hear you. So, but I'm contrasting what the situation is right now, where a unit owner, in order to be safe, would buy a $10,000 insurance policy.
Correct.
And under this new bill, we're moving it up to $25,000. So a unit owner, to be safe, would buy a $25,000 insurance policy. Correct?
And the additional cost to do that is between $8 and $24 a year.
Okay. And because the condominium association is buying insurance with a deductible of $25,000, its premium will be lower than it will when it bought insurance with a deductible of only $10,000.
Correct.
So the council of the condominium association will have a lower premium now. Do we know how much lower the premium is likely to be?
It varies. There's so many variables that go into premium calculation.
Okay. So, but the reason I'm asking these questions is over my 8 years on this committee, we have passed many bills dealing with condominiums, and quite a large percentage of them have resulted in higher fees of one kind or another to the condominium owners, so much so that we are getting people saying, especially elderly citizens, saying, I can't afford it anymore. And I think we heard the same from Senator Charles a few minutes ago. So you're saying that the additional expense, if this bill passes, to an average condominium unit owner would be in the range of, what, $8 to $24?
Yes.
Per year?
Per year.
Okay, thanks.
Yep. Okay, one more takeaway, if you'll allow me.
No, we're
No?
done with this one. We're riding off in the side.
Okay, all right.
You're quit while you're ahead.
Thank you.
You're in a good spot right now. All right. You are in a good spot. All right. Are any other questions? All right, that'll conclude the hearing for the proponents of the bill. We'll now hear from the opposition panel is Jenny Hyatt, and then Jenny Fullhouse is going to join us. Are they in the waiting room? Oh, they're here in person. Yeah, they're coming up in person. Oh, okay.
Good afternoon. Senate Judiciary Committee and Senator West, Senator Muse, the senators I know. Thank you for the opportunity to speak with you. I've listened here and I've heard some very good points, but I speak as a lowly condo owner, but I get emails all the time from other condo owners. Currently, our list is about 450. Baltimore City and County. And as Senator West said, we are just being crushed by these laws that tend to throw all the responsibility on the individual condo owner. I mean, originally you come to live in these commonly owned communities thinking we share the burden, but more and more the burden is being thrown to the individual owner, and many of us are seniors on fixed income. So let me talk about this particular bill. I'll make a point about it specifically and then a broader point. My point is, to me, it's not about the amount, whether it be 10, 25, or $1 million. It's about the principle. Should the government be in the insurance business? Should the government mandate, not recommend or request or just recommend, should they mandate that the individual owner take a certain level of risk, which is the deductible, but then they're also going to mandate, here's the solution. So we're going to create the problem, but we're going to mandate the solution. And the solution would be the bill that is coming up next Thursday. I don't know the number, but it mandates getting an HO6 policy. And it also mandates the provisions of that policy, like whether you want it or not, you've got to pay for 12 months of alternative housing. Personally, I wouldn't need it because I have friends and relatives, but I have to buy a policy that includes it because it's required. So I am against this in principle. I think it's a slippery slope. I think this should be between the insurance company and the insured. If an insurance company wants to say, we're only selling you this if you have a deductible of $50,000, that is their right, but it's also my right to say no thank you and walk away. If the state mandates it, you take away the right that every other homeowner in Maryland enjoys, which is to determine his level of financial risk and then buy a policy that covers it.
Thank you so much.
Secondly.
Nope. I think we're going to conclude there, ma'am. Thank you so much for your testimony. Your time has expired.
Oh, that's it?
Yep.
Oh,
2 minutes.
sorry.
If there
I
are
didn't
questions,
see
you
the
can
light.
expound upon your testimony.
Oh.
Ma'am, you are welcome to come up next, and 2 minutes as well.
Good afternoon, Chairman Smith and Vice Chairman Walt Stryker, members of the Senate Judiciary Committee. My name is Jeannie Polhouse, and I am a condo owner in the village of Cross Keys in Baltimore City. Our insurance deductible had been $5,000 for damage from an owner's unit to the common area or areas within the association. Then it was just raised 2 years ago to $10,000. Now Senator Kramer wants to raise it to $25,000. Not all condo neighborhoods have indoor common areas. My neighborhood has 3 condo buildings that are 2.5 stories tall, and all common areas at the entry to all units are exterior spaces, concrete floors, and steel stairways. Ever since the horrible collapse of the condo building in Florida, this legislature has enacted so many financially crippling requirements onto condo owners. Actually, Florida, having no incidents since Surfside, has revised their reserve fund law to separate condos into structural types. According to Florida House Bill 913, all condos under 3 stories are exempt from the strict structural integrity reserve study and mandatory full funding for structural components. They stated that condos under 3 stories have a lighter load, so they do not need the complex reserve study funding, but must still manage general reserves for common element upkeep with flexibility to waive funding if an association votes to do so. Senate Bill 332 is not appropriate for garden-type condos that do not have interior common areas. This will be a much greater hardship to many condo owners statewide. There are quite a few different types of condos that should be taken into consideration when writing these pieces of legislation. Types of condos include garden, mid-rise, high-rise, townhomes, etc., and different locations such as waterfront versus midtown, etc. Insurance deductibles should be regulated by the insurance companies and not the state legislature, and should be assessed according to the level of liable common areas. The Cross Keys ladies, of which I am one, started off volunteering on behalf of condo owners in the village of Cross Keys, 9 different condo neighborhoods. We now have condo owners from all across the state of Maryland that have joined our efforts and are begging for relief from these draconian laws. One size does not fit all. It is interesting that all of these reserve fund requirements were devised without any condo
Okay, ma'am,
owners'
thank you very
input. Strange, since they are the ones living in the condos.
Thank you very much. We have some
Can I
questions
just,
from the
one
Senator.
sentence.
Yes, please.
The condo owners on our list are asking us who they should support in this year's election. Of course, our opinion will be based on the results of this year's legislative session.
Thank you very much. Real talk. All right. Senator West, go ahead.
Thank you, Mr. Chair. I just have one question. If we made sure in this bill that there was no legal obligation on a unit owner to buy insurance one way or the other, that it would remain a voluntary decision on the part of the condo owner, would you still be opposed to this bill?
I would be more in favor of it than I am now, but I am opposed to the idea of one size fits all. There are different types of condo associations and buildings which require a different level of liability. And for where I live, there is no liability because we have no common areas.
That's where I'm coming from. Since if you're in a high-rise building and there's a leak, you go on a week's vacation, there's a leak, and it goes downstairs and causes serious damage to other people, then of course you want to have insurance, so you wouldn't have to pay for that. But if you just have your unit, and if something goes wrong in your unit, it's not going to affect the people 3 units away because your unit is totally separate. You could make, my feeling is you ought to be able to make your own decision whether or not you buy insurance or not.
Exactly. And the insurance company, for your high-rise example, an insurance company should be negotiating with that association because of what their liability is and not say it's for everybody in the state because it's not right.
Thank you very much for your answers.
Thank you. Yes. Oh, I thought you were signaling to me.
Thank you very much for your testimony. Further questions from the committee? All right. Senator, thank you very much. Thank you all. All right. With that, that'll conclude the hearing for Senate Bill 332. We're now going to skip down to Senator Jackson, Senate Bill 259. Do you want to bring up your panel?
Yes.
Oh, yeah, come on up, yeah, absolutely.
They need
The translator, yeah, we're setting up real quick, give me a second.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, and members of the Senate Judicial Proceedings Committee. For the record, I am Senator Carl Jackson here to present Senate Bill 259, Places of Public Accommodation, Open Movie Captioning. This legislation changes the minimum number of screens that a movie theater must have from 8 to 4 in order to be required to show movies with closed captioning. Currently, Maryland law says that any movie theater with 8 or more screens must have at least 2 screenings with closed captioning per week for each of the first 3 weeks after a film's release. However, in many places in Maryland, locals only have access to small theaters with 7 or less screens, which means that people with hearing disabilities might have to drive long distances, sometimes over an hour, in certain parts of the state in order to enjoy closed captioning accommodation. Changing this requirement for theaters with 8 screens to 4 screens would provide more accessibility to those who are deaf and hard of hearing, including seniors, and allow these Marylanders to more equitably enjoy the movie-going experience. I respectfully request a favorable report of SB 259. Thank you.
I just said that we're going to hear from the rest of the panel, and then we'll turn it over to the committee for questions. So you may proceed. Welcome.
Hello there. My name is Jacob Leffler. Thank you to Chairman Smith, Vice Chair Waldstreicher, and the members of the committee for the opportunity to explain why this bill is critically important for the passage in the House. First, I want to express my sincere gratitude for your past support and leadership in passing the previous version of this bill, which was signed by the governor in 2024. It is a pleasure to be here again to discuss this important issue that will ensure movie theaters across the state of Maryland we are accessible to everyone. Currently, the law requires that theaters with 8 or more screens to provide open caption movies twice a week for the first 3 weeks after a film's release. However, this requirement applies only to 39 theaters statewide, leaving 15 theaters exempt from providing open caption movies. As a result, many people must drive up to an hour or as far as 50 miles just to see a movie with open captions. Under the current law, theaters with 7 or few screens are not required to provide open caption movies. This disproportionately affects counties where smaller theaters are the norm. In most cases, these theaters are in the following counties are exempt: Allegheny County, Baltimore City, Calvert County, Dorchester County, Kent County, Talbot County, and Worcester County. This bill would lower the threshold to theaters to make them with 4 or more screens, helping close this accessibility gap to the Eastern Shore, particularly in the Eastern Shore, Southern Maryland, Western Maryland, Baltimore City can offer open caption movies. For example, at present, only 1 movie theater on the Eastern Shore is required to show open caption films. With the passage of this bill, up to 5 additional theaters would be included, representing a 500% increase in accessibility for this region. Open captioning allows everyone to enjoy a movie together without relying on separate assistive devices. Currently, many patrons must depend on bulky and uncomfortable captioning glasses or cup holder devices that frequently malfunction or run out of battery. When these devices fail, valuable movie time is lost, going back to the lobby, seeking replacements when no replacement is available, receiving vouchers to return another day. This process is inconvenient, frustrating, and time-consuming. Open caption movies eliminate these barriers and provide a seamless and enjoyable experience for all moviegoers. I am hopeful that Maryland will continue to lead the nation in ensuring equal access to movies for everyone. Passing this bill would make our state a shining example of inclusivity and accessibility. Thank you again for your continued support over the years. I look forward to working together to make Maryland a more welcoming and accessible state for all residents. Thank you.
Excellent. Thank you very much. All right. We will now hear from our guest who is joining us virtually. And is it Mr. Barry? Is Mr. Barry here? Go ahead. Welcome.
Okay. Thank you. Thank you, Chair, as well as members of the committee. I appreciate everyone being here, part of the committee. So on behalf of the Governor's Office of the Deaf and Hard of Hearing, I am here to express a strong support of Senate Bill 259. Legislation, this will definitely expand access across open captionings to motion picture theaters across the state of Maryland. Closed captioning, particularly open captioning, is essential in ensuring meaningful access to films for deaf and hard of hearing individuals. Places that provide public access accommodations, such as movie theaters, should be inclusive and accessible to all members of the community. Senate Bill 259 advances this principle by increasing the availability of closed caption screenings and strengthening the accountability through reporting requirements. This is especially important that this legislation applies to rural areas, just as Jacob mentioned beforehand. Deaf and hard of hearing individuals live throughout the state here in Maryland, and access to captioning screenings should not depend on geography.
No, please continue. Our apologies.
Perfect. Rural communities often have fewer entertainment options. And, maybe they'll only have one local theater within their entire community. And often caption screenings are not available, and residents don't have reasonable alternatives, effectively excluding them from full participation in community and cultural life. Additionally, reliance on closed captioning devices limit availability and as well as equipment challenges. Open Challenges provides consistent, effective, and inclusive solutions that allows individuals to attend screenings with their families without need for special accommodations. Including rural theaters also ensures accessibility standards are applied equitably and consistently across the state of Maryland. Access to cultural and recreational experience is a vital component of community inclusion. By ensuring statewide applicity of State Bill 259 helps reduce isolation, promotes equity, and it upholds civil rights of deaf and hard of hearing Marylanders, regardless of where they live. I commend the sponsors of this legislation on your leadership and respectfully urge you to favorably report on Senate Bill 259. Thank you.
Excellent. Thank you very much. All right. We have one more person sign up. Is Tina Joyner here? Like to testify? There you go.
All right. I am unable to pen.
What did you say?
Oh, here we go.
I got it. It's okay. Hello, good afternoon, Chair Smith and Vice Chair Walden-Streicher. Thank you for the opportunity to testify on behalf of the Maryland Association of the Deaf. My name is Tina Joyner, and I am president of this nonprofit organization, which represents about 1.2 million Marylanders. Members of our board have already met with deaf individuals from the Eastern Shore, many of who have strongly expressed interest in watching movies with open captioning. While some think the Eastern Shore primarily as a vacation destination, deaf people do live there year round. The Eastern Shore consists of 9 counties, yet there's only one movie theater with 8 or more screens located in the central part of the region. For some living on the northern part of the Eastern Shore, traveling to that theater and back can take up to 3 hours round trip. Is that really a reasonable expectation? Most people would say no. This issue is not limited to the Eastern Shore. Similar challenges exist in other parts of Maryland, including Western Maryland, Southern Maryland, and Baltimore City. Amending this law would significantly reduce travel time for at least 4 regions of the state and make movie theaters more accessible for deaf Marylanders. Many deaf individuals don't want to rely on captioning glasses or handheld devices. These devices are often unreliable. They may not be fully charged, may not be synchronized properly with the movie, and may not be maintained consistently by theater staff. Deaf audiences can enjoy movies with open captioning in the same way hearing audiences do. With all human beings, we all want our entertainment experiences to be enjoyable and accessible. I would like for you to consider this. If movie theaters suddenly turned off the sound for all movies, what would be your alternative? This is a question for you to reflect on. Committee members, I respectfully urge you to support State Bill 259. Thank you so much for your time, as well as your consideration.
Thank you very much, Ms. Joyner, and for the panel and Senator, thank you. Questions from the committee? Seeing none, thank you very much. All right, thank you, Senator, and thank you all very much. Thank you for joining us. All right, so with that, that'll conclude the hearing for Senate Bill 259. We'll now move on to Senate Bill he's not, all right. Let's go, yeah, we'll go with Senate Bill 319, Senator Muse.
Okay. All right, thank you, Chair Smith and Vice Chair Wall-Striker, members of this great committee, and to my friend who's come to help back me up. For the record, I'm Anthony Muse. I represent Legislative District 26 in Prince George's County. Chris Dews is here. Is Natasha on?
Natasha is also here. Yes, she's
okay. There you are. Okay. Senate Bill 319 allows the Department of Human Services to abandon the harmful practice of collecting state-owned child support payments from parents whose children are in foster care, except in rare circumstances where such collections would be appropriate. Similar to other legislation discussed before this committee, this bill's language was taken from the DHS's omnibus child support reform bill last year, giving it the tacit support of the department and the family law advocates. There's a strong connection between impoverished families and exposure to the child welfare system. Many of these parents are struggling with household instability, unemployment, and food insecurity. With these challenges increasing when under their children enter foster care. Under current practice, Maryland can compound these parents' economic stability by filing child support cases against these parents while their children are in foster care. The money paid does not support the children. It goes to the state to recover foster care costs. When these parents fall behind on their payments, they are subject to child support enforcement mechanisms like wage garnishments, tax interceptions, and license suspensions, pushing them further into poverty. In 2026, the federal government urged states not to make child support the default for parents with children in foster care, recognizing the harm it causes. Several states have already made these changes, so Senate Bill 319 follows that guidance. It limits these cases to rare circumstances and allows the state to end existing foster care-related child support orders. Families involved in the child welfare system need support, not additional financial punishment. For these reasons, Mr. Chair, I urge a favorable report. Okay? Anyone who wants to go next may go.
Mr. Chair, members of the committee, Christopher Dews representing the Center for Urban Families in support of this piece of legislation. Senate Bill 319 simply allows the Department of Human Services to stop or terminate the use of child support orders on individuals who have lost their children to foster care. This bill emerged as a part of an agreement between the Center for Urban Families, my client, Department of Human Services, and a group of fellow advocates. It is also based on a 2022 recommendation from the Federal Administration of Children and Families, who recommended that state child welfare agencies counsel policies where the default position is to refer parents to the Child Support Agency for foster care cost recovery. As this good senator mentioned, the money that is collected through this practice is not going to the children, but specifically going to cost recovery. A variety of other states have already prevented or stopped halting this process. DHS has already said that they're going to try to do this through regulations, but we decided in collaboration with them that the idea would be to also do this through legislation as well. We understand that there are some individuals who would like amendments to the bill. We are in total support of amendments. I know that there were conversations around limiting the discretion or defining in what circumstances that DHS can use this policy. And so we are actually in support of those conversations. I know, I want to say there was a testimony from the judiciary also talking about the specificity of the circumstances. We support that as well, to have those conversations. And I do just want to say that the reason why the language is the way that it is because it is exactly word for word the language that was in DHS's bill last year. We did not want to change the language as we wanted to show support for the department as this was the language that we currently agreed to. But of course, we are open to those conversations to mitigate this practice. Happy to answer any questions about the bill with the fiscal note or anything else. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Natasha Calfany. I'm an attorney at the Office of the Public Defender in our Parental Defense Division. We are asking for a favorable report on SB 319. We have submitted written testimony, and I just wanted to highlight a couple of things within that testimony. OPD represents approximately 95% of parents whose children are in foster care. So that means that 95% of those parents are living below the federal poverty guidelines. In addition, as stated, the most recent statistics in Maryland, 63.2% of all indicated neglect or indicated maltreatment findings, that means where children have been adjudicated as needing to be in foster care, were due to neglect. Neglect is almost always driven directly or indirectly by poverty. Having poor parents whose poverty has impacted their ability to parent, then turn around and have to pay child support creates additional barriers, and it is not in the best interest of children. It prolongs their time in state care. We are asking for amendments to the bill, the first being that we are requesting stronger language in guiding DSS when it can file for child support. The department already has discretion in these cases, and that discretion has not limited the practice. Secondly, we're asking for language that would require these hearings to be held as part of the child in need of assistance cases. Right now, these child support cases are separate and in addition to the hearings that parents already have to attend. It would support judicial efficiency and just support parents for these cases to be part of their Senate cases where they're already represented by counsel and the court is already familiar with their case. For these reasons, we ask for support with amendments. Thank you.
Thank you very much. All right, we have questions from the committee. Senator James.
Thank you, Mr. Chairman. I think both of you, everybody mentioned that other states have done this. What other states, or was that in your written testimony?
It should be in the written testimony. I know Maryland legally also submitted testimony where they broke that down.
Yeah, yeah, we got to see you on that camera.
Yes, there are a lot of other states. I know Washington most recently. I can get that, if you have it. Okay, beautiful.
Okay. California, Ohio, Connecticut.
Wait. I don't forget you. Just okay. California,
Ohio, Connecticut, the District of Columbia, Illinois, Minnesota, Washington, Oregon, and Wisconsin. And I want to say California also created a law that allowed them to get rid of any arrears as well.
And is this bill identical? I mean, I know we all have slightly different drafting requirements in various states. I'm not talking about, but there's no deviation from your bill as drafted for Maryland and the other states. I'm a lawyer, so I would catch a change and wonder about it. So are they identical in every respect that's meaningful?
I think, Chris. Yeah. From my understanding, yes, and that is where DHS, they took the language from other states, adopted it to Maryland. From my understanding, there is not necessarily any changes whatsoever.
And do I read the statute, I mean, the proposed bill that the judiciary opposes it, but we can get to that later, but that the child support would be terminated with some exceptions until the parent recovers custody. Is that correct? Is that the idea of it?
I believe the idea is, well, so I'll start with from a fiscal perspective. Right now, the department, and I think this is in the fiscal note on one of the last lines.
I was trying to read through that too.
Yeah, on one of the last lines, it says that they are actually spending more money trying to collect from this specific population of parents that have lost their children to foster care, primarily because, as Natasha mentioned, individuals that are in this position where they're having to pay child support when their kids are in foster care are typically there because they have been hit with some type of neglect case, which is typically associated with poverty, so they just don't have the money. And so with regards to the bill language, it was very much discretion-oriented, so it allows DHS to make those decisions and like literally go case for case with the individual. And I also want to say in the unfavorable testimony, that was part of the conversation. Like, so how are you guys going to define that? And I believe because of the language in other states, there wasn't a lot of like digging into like laying out the foundations of that. I don't know if that answered the question. I'm sorry.
So this bill is broader than just parents who have had their children taken from it to foster care because of neglect, though. It's broader. It's all children in foster care.
All children, to be clear, all children who have been placed into foster care, and the department decided to then place a child support order out against that. So it's not just like every child in foster care. It's just the circumstances where the department decided to place a child support order on those specific parents, which is case by case.
So I don't know how this works, but I thought that, let's say, a child is put into foster care very soon after birth, unwed mother's trying to figure out whether she wants to keep the child or not keep the child. I thought the law required that person, maybe they could find the biological father, to provide child support payments under those circumstances. Are you saying the law works that could happen, placed in foster care?
Yes.
But they wouldn't pay anything to the foster care system unless an order had been imposed upon them?
From my understanding, that will be how it works. Yes, that they would not pay anything unless a child support order, let me be clear, anything to the Department of Human Services unless a child support order was placed upon that individual.
And who places the orders? Is it administrative or through the courts?
I believe it is administrative.
Okay, all right.
Yeah. Did you want to speak to that or no?
I have to think about this.
Okay. Thank you very much, Senator. Further questions for the committee? All right, seeing none, thank you both very much. Thank you, Senator Muse. All right, with that, that will conclude the hearing for Senate Bill 319. We'll now move on to Senator West with Senate Bill 277.
Thank you, Mr. Chair. It is a pleasure to be here to present Senate Bill 277, which is a rather complicated bill, but I think I can simplify it for you. This is one of the bills brought to me by the Maryland State Bar Association's Estates and Trust section this year. Most of the state's estates and trust lawyers are members of the Estates and Trust section, and the executive council of the section works hard all year long on legislation to improve the operations of Maryland's Estates and Trust Code. The product of their work over the years, partnering with the General Assembly, is this huge 600-page article in the Maryland Code. In recent days, the state's Register of Wills contacted the Estates and Trust section with some concerns about this bill. As a result of their conversations, a consensual amendment has been prepared, which I think you will find on your floor system. We got it uploaded there. It may have been uploaded recently, so if you downloaded the material not too long ago, you may not have it, but it's available now. I will be discussing this bill with the amendment attached, because that's the way I want the bill to be received. Byron McFarland, on behalf of the registers, is not with me this afternoon, I don't think, unless he's on the camera. He was here earlier? Okay, well, he probably had to go home. But I believe the registers of wills are now in support of the bill with this amendment, because the Estates and Trust section and the registers of will work together to modify the bill to make it acceptable to the registers of wills. So let me describe the bill to you as amended. So here's the situation dealt with by Senate Bill 277. A person dies domiciled in another state or another country, but there's intangible personal property owned by the decedent that's located in Maryland. For example, the decedent may have dealt with a Maryland financial firm and received monthly statements from the financial firm showing the decedent's ownership of stocks, bonds, and other securities. The decedent owned the securities because they were purchased through the financial firm, and the ownership of the decedent is recorded in the records of the financial firm, but they are intangible personal property by definition in the Maryland Code. Other intangible personal property might consist of copyrights or patents or proprietary customer lists. The documents memorializing these valuable assets might be located in Maryland, perhaps in a safe deposit box, but the documents are not the assets. The assets are intangible. So under existing law, what happens to these intangible personal property assets after the death of decedent? There may be a need for them to go through probate in order to clarify the identity of their new owner and to facilitate the proper transfer of ownership. So the first issue here is what jurisdiction in Maryland is venue proper for the administration or judicial probate of these intangible personal assets. The current law in Maryland just doesn't cover all the bases. And so that's the first thing that Senate Bill 277 does. It makes it clear that if a decedent was domiciled in Maryland, the proper venue is the county in which the decedent was domiciled at the time of death. That's easy. If the decedent was domiciled somewhere else in the United States, but previously resided in Maryland, the bill, as amended, provides that the proper venue is the county in which the petitioner believes that the largest part in value of the property of the decedent in Maryland was located at the time of death. So if the decedent was not domiciled in Maryland or the United States, but had previously resided in Maryland, the bill as amended provides the proper venue is in the county in which the petitioner was domiciled or was last resided in Maryland. And finally, if the decedent was domiciled outside of the United States and had not previously been domiciled in Maryland, Senate Bill 277, for the first time, establishes guidelines as to the proper venue for administrative or judicial probate. It establishes 5 alternative tests for proper venue, any of which the petitioner may choose. And finally, as amended, Senate Bill 277 provides that if none of the above applies, the proper venue for probate is the county in which the Register of Wills, the Orphans Court, or another governing entity determines is necessary, reasonable, and in the interest of justice. Frankly, I can't figure out when that last option might be necessary to apply, but it will serve as a cleanup to cover any situation not covered by the other provisions in the bill. Oh, here's Byron, here. Okay, so we do have Byron after all. The other issue addressed in the bill is where the assets of the decedent are deemed to be located. Senate Bill 277 establishes that real property and tangible personal property are located where they are located. That's simple. But what about the intangible personal property consisting of stocks, bonds, copyrights, customer lists, and the like? If there is an instrument evidencing intangible personal property, such as a promissory note, then existing law provides that the situs of that property is the location of the promissory note. But most intangible property these days is not evidenced by instruments. Time was I had stock certificates. When I was a young lawyer, I had stock certificates. And I actually had some bonds that I inherited from a relative I kept in a safe deposit box. Twice a year, I had to go downstairs with a pair of scissors and cut a little coupon at the end of the bond and take it and deposit it in order to recover the interest from these bonds. But those days are over. These days, stocks are not held in instruments. Bonds are no longer held in instruments. They're all online. So they literally are intangible personal property. So most intangible property these days is not evidenced by instruments such as promissory notes. And to deal with these situations where there is no instrument, Senate Bill 277 adds language to the Maryland Code stating that the situs of intangible personal property is the domicile of the decedent. So if the decedent was domiciled in Nebraska, the situs of the intangible personal property was Nebraska. If the decedent was domiciled in Spain, then that's the situs of the intangible personal property. And this is because the law of the United States has always been that the intangible personal property is taxed where the decedent was domiciled. Otherwise, if the intangible personal property were taxed where it's located in a different place than the domicile, some state like Nevada, for example, would form a depository. And everybody would move their stocks and bonds and everything to Nevada because the taxes on it in Nevada would be infinitesimal. So the law in this country has always been that intangible property is taxed where the domicile, in the domiciliary state or location of the decedent. So Senate Bill 277 thus makes it crystal clear that, to quote the bill, quote, the situs of intangible personal property is the domicile of the decedent. I strongly recommend this bill to the committee. I know it's complicated. I'm sorry about the complication, but it clarifies the law in these situations so people won't have to guess what the law might be, and there won't be litigation to determine what the law is. This bill will establish what the law is. And with that, I give you Byron McFarland, who is the Register of Wills of Howard County, who can further explain the bill.
Good afternoon, Mr. Chairman and members of the committee. My name is Byron McFarland, Register for Howard County. Senator West, thank you for the bill. And Senator West and Senator Charles, it's good to see you both in person. After all of our hard work this past fall on our fiduciary task force, I look forward to our continued work together. Senator West did an eloquent job explaining this bill. Very simply, I always like to tell people that probate law in Maryland is old. Most of it was written before most of us were born. And so it did not necessarily envision the world as we live today in 2026, where people are more multinational, international, people are more mobile, and we're dealing with, especially in jurisdictions where we have a large foreign-born population. Howard County, for example, 22% of our residents are foreign-born. Therefore, they have lots of relatives who live in, at least in Howard County, India, South Korea, China, United Kingdom. We deal with a lot of folks who live abroad or have relatives who did live abroad when they passed away. So what this legislation will do, and I was very pleased to work with in anticipation of today's hearing, work with our partners in the Estates and Trust Law section of the Bar Association to work out a compromise with the amendment that Senator West explained, that will simply say if a decedent died outside of Maryland, but they have some kind of intangible asset, a bank account, something like that, that was created here, the family has something to do with it, that it would be where they last lived. So just as an example, if, let's just say, I'm born and raised in Howard County. If I decided to move abroad, but before I move abroad, I go down the street, I open a checking account at CQ. I don't have a joint owner on it. I don't have a beneficiary on it. I put some money in it, and I relocate, and I'm domiciled in the United Kingdom when I pass away. My estate will be opened in the United Kingdom, but what happens to that CQ account? My family here in America, in Maryland, will be left to do something with it. So where would that be dealt with? I live in Howard. The last place I would have lived would be Howard County. So that's what this bill does. It really just brings us into the modern era as, again, people are much more international, multinational, and this will also deal with some tax issues. So with that, I support this. And again, Byron McFarland, Register for Howard County, for the record. So we support this favorable with amendments, Mr. Chairman. Thank you.
Excellent. Thank you very much. Thank you, Senator Sidnor.
Thank you. Just for purposes of this, how is your domicile determined?
I'm sorry, can you repeat that?
How is your domicile determined?
Domicile is where you rest your head every night. We typically look at it as where you're registered to vote, where's your driver's license, where you pay your taxes, those kinds of things.
So I'm trying to understand, so with the example that you gave where the person moved abroad, I'm just trying to make certain that does there have to be some sort of an election?
Sure. So if you're living in Spain when you die, and that is your current domicile, then that would, for purposes of this bill, that would be your domicile.
Right. So how is that? So there has to be some evidence that I'm domiciled there, not necessarily just on a long extended vacation there. That's what I'm trying to.
There's a lot of law over the years, much of it judge-made law, about how to define domicile. Okay. If you're on vacation, that does not count as being a domicile. You have to change. Once you have a domicile, you have to affirmatively change your domicile to a different location.
I know there was a number of years ago when I introduced legislation about how we run for election, there was a distinction between a domicile versus a place of abode.
Interesting. One of the main sources of this law was the case decided by Chief Judge Bell about Senator Blount. Senator Blount had established a residence in a condo in Baltimore County, but he still maintained his old residence in Baltimore City. And the holding of that case was that because he had not affirmatively taken action to change his domicile remained in Baltimore City, and he could run and be elected as a state senator from Baltimore City.
Right, and for election purposes, we changed that. Okay. Thank you.
Sure.
Further questions from the committee? All right, seeing none, thank you both very much. With that, that'll conclude the hearing for Senate Bill 277. We're now going to move on to Senator Charles with Senate Bill 353. Ms. Highland is on the panel, and Marceline, Ms. White. Come on up. Hope that wasn't your dinner.
Definitely all my snacks crushed.
That's all right, I'll take care
All right. Thank you, sir. Good afternoon, Chair Smith, Vice Chair Wall Striker, and the honorable members of the Judicial Proceedings Committee. For the record, my name is Senator Nick Charles, representing District 25, and I'm testifying in strong support of Senate Bill 353. If you remember, I introduced this bill last year, so this is a reintroduction, and it responds to a very real and growing problem in Maryland, so-called zombie mortgages. The House cross-file of my bill passed unanimously last year, 139-0 on the House floor last year. So obviously some things happened. We weren't able to get the bill out. So hopefully this year we'll have some success. So with that being said, I'm just going to re-educate you a little bit on the zombie mortgages. So zombie mortgages occur when a foreclosure case stalls and is dismissed or goes dormant, leading homeowners to reasonably believe that their debt has been resolved, only for that same debt to be sold to a new buyer and revive the foreclosure many years later. These are not active good faith enforcement actions. There are often old loans that have been bundled, sold, and resold with spotty documentation and revived only after a property has regained value. Families are blindsided by decades-old claims, their titles are clouded, and their homes are put at risk at precisely the moment that they thought they were safe. Even savvy, financially responsible homeowners can fall victim to surprise, decade-old zombie foreclosures because the notices and record transfers are often confusing, incomplete, or buried in technical filings. This is not a hypothetical risk. It is a repeat of the foreclosure crisis by another name. Senate Bill 353 is designed to stop the predatory practice and restore basic fairness to our housing system. This bill establishes two clear targeted protections. First, it requires that an order to docket or a complaint to foreclose on a residential property be filed within 10 years of the alleged default. There's going to be some testimony from opposition that they want to increase it to 12 years, but we're willing to have that conversation. That provides finality for the homeowners while still giving lenders ample time to act. If a secured party waits a decade to pursue fair foreclosures, the delay should fall on them, not on families who have lived under a cloud of uncertainty. Second, if a secured party acquires debt that has already been in default for 5 or more years and then seeks to foreclose, the bill requires that the party submit the same documentation required of a debt buyer under Section 5-1203 of the Court and Judicial Proceedings article. In other words, if you are buying and enforcing very old debt, you must come to court with clear proof that you actually own it and have the right to collect. This is not a burden. This is basic standard of evidentiary transparency. Importantly, Senate Bill 353 does not interfere with legitimate foreclosure activity. Existing exemptions remain intact for fraud, bankruptcy-related defaults, destroyed properties, and vacant or abandoned homes. Lenders and servicers who actively manage loans, communicate with borrowers, and maintain accurate records will not be hindered by this legislation. This bill, narrowly tailored to address only these cases where extreme delay and poor documentation create unfair surprise and hardship. From a broader perspective, zombie mortgages harm more than individual homeowners. Lingering, dormant liens, trapped properties, and legal limbo depress neighborhood values and destabilize communities that are still recovering from past foreclosure waves. Senate Bill 353 brings certainty, clarity, and stability back to our housing market. Homeownership should not come with a permanent cloud hanging over your title. Maryland law should not allow foreclosures to rise from the grave. No more zombie mortgages. For these reasons, I respectfully urge the committee issue a favorable report on Senate Bill 353. And with me today, I have Kat Hyland from the Office of Financial Regulation and Marceline White from the Economics Actions Maryland to testify in support of this bill and answer any questions, and I mean any questions. Thank you for your time and your consideration. 20, come on up.
Good afternoon, Chair. Thank you, Chair, members of the committee. My name is Kat Highland, and I'm the Deputy Commissioner of Financial Services and Consumer Protection for the Maryland Office of Financial Regulation. OFR is testifying in support of Senate Bill 353, which addresses residential foreclosures involving very old mortgage debt or materially delinquent mortgage debt. This bill is designed to protect homeowners from foreclosures on mortgages that have been in default for many years, sometimes a decade or more, often without any communication from the lender during that entire time, often also a second mortgage on the property. In practice, these mortgages are usually held by debt buyers who purchased the loans after they were charged off after non-payment by the original lender. Because homeowners may have not heard anything about the loan for many years, and in many cases that we have heard about are actually current on their first mortgages, many reasonably believe that this debt no longer exists or was forgiven or was modified if they did any kind of loan modification, which many did after the Great Recession, when in fact the loans weren't. As housing values have risen, we're now seeing these old loans resurface. As hopeful debt buyers are trying to claim equity on the property. They often are filed with years of accumulated interest and fees, sometimes without the requisite monthly statements under Maryland law. So from OFR's data, we can see that this is roughly 1% of the foreclosure filings in Maryland. So a small slice, but a slice that is impacted very greatly. For the homeowners, the impact is enormous. Our analysis shows the average amount required to avoid foreclosure in these cases is often $193,000, again, impacted by the fees that have accumulated over time, sometimes not legally permissible. It's an overwhelming sum for most families to raise. And at the federal level, the CFPB has said certain protections exist when we're dealing with time-barred debt. Unfortunately, those protections don't apply in Maryland because foreclosures are not subject to a statute of limitations. So to increase these protections, we urge a favorable report on Senate Bill 353. Thank you.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland Fund, and we're here in strong support of Senate Bill 353. As Senator Charles noted, this version of the bill is dramatically revised and passed the House last year, and it does a couple very simple things. First, it establishes a statute of limitations for foreclosures, and secondly, it requires debt buyers who hold properties for 5 years or more to document through a chain of title that they have the ability, they own this property and have the ability to pursue a foreclosure. I want to be clear, only 2 states in the country, Maryland and Alabama, do not have a statute of limitations on foreclosures. All of the other 48 states have statutes of limitations, and all of the states have a thriving mortgage and secondary mortgage market and strong access to credit. A statute of limitations provides clarity and transparency to the homeowners and starts the clock so they know they have 10 years and gives the banks a timeline to be held accountable and to move forward with a foreclosure action. The requirement for documentation is something that debt buyers already have to do under Maryland law. This simply brings these kinds of delinquent properties under current Maryland law. So debt buyers already know how to do this. They already have to do this under Maryland law. And it puts important guardrails in place for homeowners facing foreclosures and those with these unexpected zombie mortgage bills. So we believe this is critically important. They need to apply appropriate documentation. And for these reasons, as we see foreclosures tick up across the state, we urge a favorable report on Senate Bill 353. Thanks.
All right, thank you very much. Senator West.
Thank you, Mr. Chair. I think, Senator Charles, you talked about the difference between the 10-year statute of limitations and the 12-year statute of limitations. And I can't find it right off the top of my head, but one of the, it was the Maryland Legislative Action Committee of the Community Associations Institute points out that we already have a 12-year statute of limitations and have had for a very long period of time. So would you have a problem amending the bill to apply 12 years instead of 10 years?
Yeah, me personally, I don't. Right, but, you know, I have this bill cross-filed, and I want to make sure the cross-file from the House side is actually in alignment as well, but I do know about the 12 years.
So here's my
that's already
concern.
in place.
So everybody in the industry knows that there's a 12-year statute of limitations. You have to commence an action on a written instrument within 12 years, or else you lose your right. So you could well have organizations which, as to which a particular mortgage is over 10 years old, but not yet 12 years old. And they figure they've got an extra year and a half or so to commence foreclosure or lose their rights to do it. If this bill went into effect, I don't see any grandfather clause. So it would effectively extinguish those obligations, those mortgage obligations, prior to the statute of limitations time, which has always been in the law. And I wonder about the constitutional implications of that. But we're basically taking a step which would literally extinguish existing contracts with no compensation to the contract owners. So I would suggest you go, unless you've got an answer for that issue, and maybe somebody in your panel does, I would suggest you go back to the House sponsor and see whether or not you all are willing to conform this bill to the existing law, which is a 12-year statute.
Like I said, I'm fine with 12, but I'll let them answer the other technical portions.
Sure, thanks.
Sure, and we agree with the sponsor in that we can certainly discuss 12 years versus 10 to not
I think if you do 12, you're not going to have a
Marylanders.
problem.
We just wanted to clarify that currently there is no statute of limitations that applies to foreclosures in Maryland. So we're all clear on that. But you're discussing contracts under seal, and I understand that we would want to conform to the bracket that most people identify with.
Right.
So
Okay.
I don't think that would be problematic.
Great. Thank you much.
Thanks.
Further questions from the committee? All right, seeing none, thank you all very much. We'll now switch to our opposition panel. Mr. Etten is here in person, and we have Scott Nadell, who's joining us virtually. We'll hear from Mr. Etten first.
Thank you very much, Mr. Chairman, members of the committee. Robert Etten on behalf of the Maryland Bankers Association. You know, going back, I guess, to 2000, I forget now which, when the bottom fell out of the real estate market. I've been up to my ears in foreclosure legislation and issues. I would urge you really for a couple points, and that is that the secondary market is critical. If someone makes a mortgage loan, whether it's a bank, a mortgage company, whether it's, you know, they make a loan, and if they can't sell that mortgage into the secondary market, they don't have any money to make another loan. So we have to tread very, very carefully when we deal with mortgages to make sure that we're not doing something which would have a negative impact on the secondary market. I've reached out to the Federal Home Financing Administration, FHFA. They are the ones that regulate Fannie, Freddie, and the secondary market. I'm waiting for feedback from them on the bill to make sure they don't have a concern with it. The other thing that I would stress to you very much is that this 5-year is a tremendous penalty for people that may purchase a mortgage that's in default. I'm not aware of a 5-year statute of limitations like this on any lending. Right now, there's no statute of limitations. The number, if you look at the fiscal note, I'm sorry, if you look at the testimony from the Department of Labor, you'll see that that homeowners mistakenly believe they are no longer owed the debt if you don't seek to enforce it. Well, frankly, I really have to question that. I think if I'm a borrower and I have a mortgage, just because nobody's demanded it, I think that all of a sudden it's no longer in effect. In addition, they say it will impact a very small percentage of mortgages in Maryland. I would tell you that for mortgages more than 5 years, they estimate that outstanding, there are 3,400 out of 464,000.
Sorry, I know
I didn't see my time was up. I apologize.
We've got, I think we've got a couple questions. Senator Sidnor has a question, but we're going to hold that until we hear from Mr. Nadel first, and then we'll address the panel together. So, Mr. Nadel, you're up. Welcome.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Scott Nadel. I'm the chair of the Maryland State Bar Association Real Property Section, but I'm not here in that capacity today. I'm just here as a practitioner, and I'm here to respectfully urge an unfavorable report on Senate Bill 353. This bill creates significant unintended consequences for Maryland's housing and credit markets. At the center of the issue is a legal distinction that matters, the difference between the debt and the lien. Debt collection actions already have a time bar. Foreclosure actions are not traditional collection cases. That distinction is longstanding and repeatedly confirmed by Maryland appellate courts. The lien is recorded in the public land records, and buyers, lenders, and title insurers all rely on that system. SB 353 would impose a fixed 10-year deadline measured from default. Mortgage defaults are often not single events, and loans are frequently modified, reinstated, placed into forbearance or cured and redefaulted. Servicing transfers occur. Bankruptcy stays interrupt enforcement. Loss mitigation efforts can extend over years. A rigid timeline, a deadline tied to an initial default date will generate litigation over when that clock started, whether it was reset, whether tolling applies, and instead of clarity, the bill risks years of new procedural and constitutionality disputes. With a fixed limitation clock running, it means fewer workouts and shorter negotiation windows. A rule meant to protect homeowners could produce more rapid foreclosures. The bill also calls for extra documentation for loans that have been in default for extended periods and later transferred, effectively turning them into collection cases, which they are not. Current requirements in foreclosures already call for filing of numerous documents, and courts already have the authority to demand additional proof and to deny relief when the proof is lacking. There is also a credit cost impact that should not be overlooked. The likely results in tighter credit, higher rates, reduced availability of second lien and home equity lending. Those are important sources of liquidity for Maryland homeowners. And finally, we must recognize that existing law already contains meaningful borrower protections, mandatory pre-foreclosure notices, I'm wrapping up right now, waiting periods, robust mediation opportunities, and bankruptcy protections. The current framework works. In short, 353 replaces a nuanced framework with a rigid deadline rule and will increase litigation, accelerate foreclosures, and raise credit costs. And for those reasons, I would respectfully request an unfavorable report. Thank you.
Thank you very much, Mr. Nadel. We've got a question from Senator Sidnor, then Senator Watt.
Thank you. And I don't know if the current framework does work. I remember some years ago reading articles about homeowners who were foreclosed on because of these types of zombie mortgages. But if I might ask, this is the question. There's a statement in the question. Maryland Supreme Court says that there are no statute of limitations for foreclosures. Is that accurate?
Yeah, right now there is no statute of limitations on foreclosures. That's correct. And let me just say, Senator, that the primary concern that I have more than anything is with this 5 years that for a mortgage that's delinquent. That's a major concern of mine. Probably the biggest concern I have is if we're going to change this. We've never had a statute of limitations on mortgages. We've never had mortgages be.
That's here for the state of Maryland, though, right?
I'm sorry?
But that's here in Maryland?
Yes, in Maryland.
But there are states that do have statute of limitations on
there is no statute
right?
of limitations on foreclosures in Maryland today. Other states, I don't know about other states.
I had one that says that I believe Maine has a statute of limitations on foreclosures.
Yeah, I'm not as concerned about there being a statute of limitations. I think one of the biggest areas of concern is that this bill just says it's effective when whatever the October 1st, whatever it says. And
so you concede on statute of limitations?
It should not apply. It's got to have language in there that makes it prospective. It can't apply to mortgages that are out there today.
So then you are conceding on statute of a bill having statute of limitations. You're fine with that?
I'm sorry?
Are you saying that you concede to having a statute of limitations?
That's not my major concern with the bill.
That's not a major concern.
The 5 years is a major concern because I would just.
But if it was consistent with.
This 5-year provision, I'm not aware it exists any place under anybody's law. And if you look at the testimony from the Department of Labor, you will see that the number of mortgages that fall into this category with this 5 years is 0.4%. We have over 1 million outstanding mortgages in this state of Maryland. But whatever we do, it's got to be prospective only. It can't apply to existing mortgages. They have to be mortgages entered into on or after the effective date of the bill. So that people that make a loan, whether it's you, me, or a bank, understand just what the risks are and what's out there. And we need to make sure that the secondary market doesn't decide we're not going to buy Maryland mortgages anymore if we pass this bill. That's my concern. I look forward to getting back to the committee with more information.
Thank you.
The retroactive abrogation of vested rights, this committee's gone down that road before, so. All right, Senator West, go ahead.
Thank you, Mr. Chair. Exactly. That's the route I wanted to go down, I guess, with Mr. Nadal. Mr. Nadal, you're the head of the real estate section, or the real property section of the State Bar Association?
I am, but I'm not here today for that.
I understand, but that means you have a certain familiarity with these real property statutes we're talking about. Do you see any constitutional concerns about a bill that will eliminate the possibility of foreclosures for existing mortgages that are beyond, as the bill's written, beyond 10 years old?
I think that I share your concern. I think that exactly the question that you asked earlier, when you have a contract that is an otherwise legal contract, and now you're going back, that's already been entered into, and now you're going to talk about restricting those rights prospectively, retroactively and not prospectively, I think that's a major constitutional problem. You're not allowed to do that. I think that that's a real problem.
Okay. Thank you.
Oh, yes, Senator James, go ahead.
I can't remember from last year, because I think we did have a bill in last year, right. This good senator has introduced the bill this year different, trying to mirror what the House did, amended the bill. So last year, did you have problems as you'd have today with the bill that was originally introduced in the Senate, passed out of the Senate, that are as emphatic as the ones you have today, which are based on a bill that was amended to reflect the House's alterations?
Okay, so let me be clear on that.
I'm trying to figure out whether some of those changes may be the crux of them.
So let me be clear on the history. The bills were cross-filed, and the good senator had the Senate bill, and there was a House bill. The Senate bill got a hearing. I testified against the bill. It was completely different than the bill that you have in front of you today.
That's my memory.
So on the House side, it was identical. They were cross-files.
Right.
And on the House side, in the Real Property Subcommittee of the House Environment and Transportation Committee, amendments were offered which completely rewrote the bill, and it passed out of the House in the form that you have it today. The good senator's bill did not make it on a voting list in this committee, and the House bill did not have a hearing in this committee. So the bill you've got before you was never reviewed by you. Okay. I never saw this language until it had already been approved on the House side. Had I had the chance to testify against this on the House side last year, trust me, I would have testified against it.
So I can look this up, your testimony from last year, but it would be helpful if you would send us a copy of it, just make it a little bit easier.
Sure.
Because what I'm trying to figure out, not that I want to hijack the senator's bill, you're going to do it, whether or not the bill that the senator supported last year was something we could work with and possibly, if need be, and would not engender as much strong opposition, both you and I know the private lawyer who happens to be also, with the real property division of the Maryland State Bar. But I understand you're testifying just as a practitioner.
I would be perfectly frank with you, Senator. The bill as introduced last year was very problematic as well.
Even the one on the Senate side.
Yeah.
All right. Well, that's fair. Thank you very much.
And I'm sorry, what is his name from? Mr. Nadell. You had mentioned something about contracts earlier, and just to establish your expertise, how long have you been practicing the law in this area?
Since 2003.
Okay. Is it fair to say that mortgages on that face say that the law may change?
I'm not sure I understand your question.
Do mortgages acknowledge that the law may change over the life of that mortgage in the contract?
I don't know. I don't know. I know that most of the deeds of trust that are out there or mortgages will discuss what law would apply, but it doesn't discuss necessarily changes in the law. Not that I'm aware of.
Is there a vested right to remedy in mortgages?
A vested right of remedy. Could you explain your question? I'm so sorry, Senator. I don't follow your question.
Within the document, does it speak to certain remedies being vested for the mortgage holder?
Generally, there's a power of sale in a deed of trust. Usually now we use deeds of trust. There are not too many mortgages that are generally out there, but deeds of trust call for a power of sale.
Okay. So to my point, is there anything that's some sort of vested remedy?
The lender, under default, could exercise its power of sale.
Well, let me ask you this question, because it was shared with me that many a times in court, banks and mortgage holders, they argue that they can change the terms of loans all the time. Have you ever heard that argument made in court?
I suppose if there is a loan modification between the parties, they modify when something is owed or how much is owed or under what period of time or interest rates that could change. Things like that, generally between the parties. Yeah, sure.
I'm done.
I think, can I try it again? Because I think it's not the, I guess what we're trying to ask is the particular remedy a vested right? Is there a particular remedy? Is that what you're asking? Okay. Now, the ability to collect, understood, but is a particular remedy vested?
Yes, it discusses through the power of sale to be able to foreclose. And the distinction is generally not the debt action that is in a foreclosure, is just a property right. It's not the debt issue. A collection suing on a note is different than a foreclosure action.
Just to follow up, sir, you on the video, I apologize, I don't have your name, but I understand exactly why you spoke so quickly, because it's 2 minutes, but it, flew by me, and I checked the file and my colleagues, and we don't have any written testimony from you. For me, as a practicing lawyer, also, I am interested in what you had to say, but I can't process it. Hopefully you were reading something, and would you be willing to share it or clean it up a little bit so that we could digest it at a more leisurely pace?
Sure, I'd be happy.
Okay. And then you are, I don't know if you said you were a member of the real estate section of the Maryland State Bar, or Perhaps you were leading it. I don't know what you said, but I guess my question is, since you're familiar with that section, have they taken a position on this bill, to your knowledge, this year or last year at all? Do you know?
To my knowledge, they haven't, and that's just because a lot of sections don't get too involved because you've got people on both sides, and so
Sure.
the association doesn't like to
I
be.
don't make any assumptions about that, because I do understand they can't address everything. They're on full-time staff to do this. I just wanted to know if you were aware of a position that I may not be. And so there isn't a position that you're aware of that has been put into the file for us.
That is my understanding.
All right, thank you very much. That's it.
Excellent. Okay, further questions from the committee? All right, seeing none, thank you very much, Mr. Renton. Thank you very much, Mr. Nadell.
Thank you.
With that, that'll conclude the hearing for Senate Bill 353. Thank you very much, Senator. We'll now move on to Senate Bill 269 with Senator Henson.
Thank you, Mr. Chair. As the panel approaches, thank you, very patient panel. Thank you, colleagues. I am Senator Shanika Henson, here to present Senate Bill 269, the rebuttable presumption on medical bills. First, I'll start with who this bill is about. This bill is about people who have been severely injured. In this committee, we often hear from people who level the criticism against our committee that we spend a focus on people who have harmed people, but we don't spend enough of a focus on people who have been harmed. This bill is exclusively about people who have been harmed. In order to be affected by this bill, you had to have first been harmed. It is not maybe you were harmed, it is you definitely were. In the context of a civil case, you have two phases of the case. You have the finding of liability, where you go through the case to figure out was someone injured or not. And then the second phase you get to is, okay, someone was injured, now we figure out what we're gonna do about that injury. So we are only dealing with the second phase of that after there's a finding that someone was injured. There's also different levels to that. If someone has been injured, if they were injured to a certain extent and what they can recover for that is under a certain dollar amount because their injuries weren't as severe, then what you are doing would not be covered by this bill either, because that already exists in law. So the who of this bill is people who have been severely injured. That's who this bill is about. What this bill does, this bill creates a rebuttable presumption that medical bills that are entered in a case are authentic, are fair, and are reasonable. That's what this bill does. So as the medical bills are entered in, it would have those three factors that would be presumed on its face when the bills are entered. Now, the judge or the jury would still get to decide any sort of verdict or award. So just because you enter your medical bills doesn't mean that that's automatically what the court has to do. They have to say, well, that's the amount of the award of damages. They still have to make that determination. So what you're going to hear from the panel today is people who represent folks who have been severely injured. They're going to share with you stories from their clients. They're going to share with you stories from what it's like to get medical bills admitted into evidence, something that should be simple that's far too often made very, very complicated. After this panel, you are going to hear from people who will tell you you should not do this, and they're going to give you a few reasons why, and here are some of those reasons. One of the reasons you're going to hear is that we have a process called remitter, where after a person or a trial happens, people can petition the court after that, and they can say, this verdict is excessive, Your Honor, and we want the court to look at it to see if this verdict is excessive and if it's unreasonable to make a determination. And they're going to say that if you have this bill passed, then the court can't make a determination on reasonableness. That simply is untrue. The court can make a determination on reasonableness, and this bill will not change that. You don't see any of that language struck out from the existing rules. You don't see any of that language struck out from any article in courts and judicial proceeding. That is unaffected by this bill. Whether the determination on entering these bills is made by a finding or is made by a presumption, that will not change what happens in the process of remitter. So you'll hear that, but just remember, that's not what's happening in this bill. Another thing that you will hear is that burden shifting. We can't have a defendant be responsible for the burden of proving that these bills are unreasonable. That's not how cases work. The plaintiff always has the burden. There is no precedent for requiring the defendant to have a burden. That as well is untrue. There are instances where the burden of proof is on the defendant. It happens in an employment law context. If any of you are employment law practitioners, you know that the person makes a prima facie showing that they were discriminated against at the job. And then it is that employer's responsibility to show they took the action for a non-discriminatory reason. We've made that as a policy decision here in the state for a variety of reasons, but it happens. It has a precedent. So if you hear it is unprecedented to have the burden shift, that is simply not true. You may also hear today that the medical bills that people admit into evidence are inflated and unrepresented of the actual costs that are paid. The medical bills on their face may be unrepresented of the actual costs that are paid in instances, but that is not going to change with or without this bill. So if you hear that, please understand that this bill will not change that. The same medical bills will be entered into evidence if you pass this bill or if you don't pass this bill. What this bill will do is determine who's going to have to hire an expert to say what those medical bills mean. That's what this bill will change. It won't change the bills. If our colleagues in the Finance Committee want to make a rule about what you can put on a medical bill and what you can't, then we will trust their judgment if they want to do that. But that's not the purview of this bill. So if we pass it or not, if you don't like what's written on a medical bill, that's not what this bill does. This bill will simply say, if you put a medical bill into evidence and you want to challenge it, it is going to be on the defense counsel to decide to hire that expert and to challenge what's on the face of that medical bill. And then lastly, the ultimate argument that we always hear is you are going to hear, if you pass this bill, it is going to raise the cost of claims. It is going to make everything so expensive and the session on affordability that everything is going to become so inexpensive. And I'm going to tell you why that is not true. You can look at the fiscal note and you can discern that by the fiscal note itself. When you look at the fiscal note, what you see is any sort of argument that this will raise the cost of insurance claims is purely speculative, because even the expert drafters of our fiscal note could not pin down data to support that this would raise the cost of claims in the state of Maryland. And the reason for that is because the same process that happens in courts every day is going to continue to happen in court every day if you pass this bill. The only thing that will change is who hires the expert to come to court to challenge the medical bills that are entered into evidence. That is the only thing that will change. It will not make damage awards higher. It will not make the cost of claims higher. It will simply mean that those experts will be brought in by the defense counsel instead of the plaintiff's counsel. And here is why that matters. Because the plaintiffs in these cases are your constituents. The people who have been harmed, the people who have been in auto accidents where they have been severely injured, the people who have been harmed in various ways that you'll hear from counsels who represent them, those are the people who sent us here to Annapolis to make sure that the laws work for them. And when we require them, after surviving their injuries, to shoulder all the cost of litigation, what we are saying is that we think the companies that
harm them, and the insurance companies that routinely delay and deny their claims are more important than giving them the one thing that we can give them, and that is the opportunity at a small measure of recovery in the form of damages to make themselves whole. So colleagues, I hope that you will hear in the testimony presented to you the opportunity to restore to our constituents some measure of hope and help when it comes to this bill. Thank you.
Chair, Vice Chair, and members of the committee, my name is Neil Dubovsky, and for the past 23 years, I have had the immense privilege and honor of representing and helping secure justice for injured Marylanders. I'm here today regarding the bill that Senator Henson was very gracious to sponsor, because currently in Maryland, in order to ask the jury to award medical bills in a case on behalf of one of our clients, we as plaintiffs are required to present evidence through an expert witness that the medical bills incurred were fair and reasonable. Now, this requirement exists in every single case, and it exists even though in the overwhelming majority of cases, the fairness and reasonableness of those bills is not actually in dispute. As a result, plaintiffs are required to expend resources having an expert testify to something that nobody questions. Experts are inconvenienced by having to appear and testify to an undisputed issue. And additionally, judges and jurors are subjected to an inefficient and time-consuming process that is essentially inefficient and unproductive. This bill cures all of those issues, and it promotes judicial efficiency by eliminating the financially onerous and time-consuming requirement. It establishes that medical bills are presumed to be fair and reasonable, absent evidence to the contrary. Importantly, as built into this proposed legislation, the bill still affords the defense the opportunity to dispute the fairness and reasonableness of any charges if and when they're actually at issue. Now, some of the opposition to this bill talks, as Senator Henson mentioned, about the increased cost. The reality is this is purely a procedural measure. This is not going to cause verdicts to go up or down. In fact, it's not going to have any impact at all. The only thing at issue here, the only thing this bill does is it ensures that procedurally, plaintiffs are not required to expend resources. They're allowed to keep more of their money from a judgment because they're not having to pay an expert, and it promotes judicial economy and efficiency. And for those reasons, we respectfully request that a favorable report on this bill. Thank you so much.
Thank you. Thank you for the opportunity to testify in support of this bill. I'd like to explain what the bill does, kind of reiterate what it does, emphasize what it does not do. Innocent plaintiffs in an action for personal injury are already allowed to recover the reasonable value of the medical care rendered to treat their injury. Contrary to what the opposition says, this bill does not change anything about that. It doesn't change what medical bills the plaintiff can claim. It doesn't change what a jury can award or what a verdict is likely to be. And it doesn't take away the defendant's right to challenge any particular bill as being unfair or too high. All the bill does is simply streamline how an innocent plaintiff can prove something that's almost never truly in dispute, that the medical bills are fair and reasonable. And it brings in the circuit court in line with the district court, which has had a rule like this that allows it to come in without a witness for 20 years. Take this for an example. An innocent plaintiff dies while being treated at a Maryland hospital due to medical malpractice. That hospital charges its standard rates for the care that he received after the medical malpractice, rates that are actually set and regulated by our state's Health Services Cost Review Commission. And then the family medical expert testifies that the bills in the case were fair and reasonable. The hospital's lawyer then spends time cross-examining him. Doctor, you're not an expert on hospital billing. You don't set prices, implying that the physician shouldn't be allowed to testify, making that family then bring in another witness, maybe the hospital's own billing manager, to say under oath, of course, these bills that we have are fair and reasonable. That makes no sense. Forcing a grieving family to drag in a billing witness just to say, yes, the bill is fair and reasonable, when it's not even in dispute, makes no sense. So on behalf of the injured Marylanders who need access to justice, not procedural hoops, I respectfully urge a favorable report on this bill.
Good afternoon, Chairman Smith. I'm Emily Malarkey. I'm this year's legislative chair for the Maryland Association for Justice. You've heard about why this bill will not in any way, shape, or form change the amount of jury verdicts that are awarded in our state and thus have absolutely no impact whatsoever on all of our insurance rates. What you are also going to hear from the opposition is, or will not hear from the opposition, is the fact that if a plaintiff recovers an award in a personal injury case that includes medical bills, a lot of that money, if not all of that money, in the vast majority of cases, has to go back to the health insurance company or to Medicare or to Medicaid. In other words, the plaintiff isn't even recovering that money in their own pocket in the first place. What we see time and again in our cases is that this requirement is used as a procedural hoop and a strategy to drive up litigation costs, take more time, and therefore make litigation more expensive and difficult for our clients. And I'll give you a couple of examples. I had a case where I represented a man who spent 11 months in the University of Maryland medical system, and his bills were paid by Medicare. The defendant convinced the judge that he needed a lengthy postponement of the trial to hire a billing auditor as an expert witness to come into court and to testify that the University of Maryland's bills that were paid by Medicare were not fair. And shockingly, the auditor that he hired after this lengthy postponement concluded that the fair market value of the bills was actually more than what had been charged. So the postponement served no purpose other than delay. I had another case involving a gentleman whose leg was amputated and his care was provided by multiple different medical specialists. Instead of parading 4 or 5 different doctors into court to testify, I hired a life care planner to talk about all of them, which took 2 hours of the jury's time. There were not even 2 minutes of cross-examination questions of that witness and no argument to the jury at trial that the bills were fair and reasonable. This is a procedural hoop that is designed to make it more difficult for plaintiffs to litigate an issue that is never in dispute, and for that reason, we urge a favorable report on this bill.
All right, thank you very much. That'll conclude the testimony for the proponents of the bill. We'll open it up for questions. Senator Love.
Thank you, Mr. Chair. So you've talked about the experts that you have to bring in. How often does the defense contest the fairness of the bills?
So they can come in a couple of different ways. There can be a stipulation or an agreement by the other side that they're fair and reasonable. That happens sometimes. If it doesn't happen, we either have to bring a billing representative in from the institution or institutions and parade them into court to say, yes, this is the bill, yes, it's fair and reasonable, these are customary charges, or we have to have an expert. The problem is if it's an expert doctor, sometimes if it's an orthopedic surgeon who's testifying and the bills are for pain management or wound care, the expert doesn't know if those bills are fair and reasonable because it's outside of their expertise. And so it's this artificial requirement. You know, if Maryland hospitals and healthcare providers are charging reasonable and customary rates, there should not be a dispute. It does come up from time to time, but what we have is this wonderful thing in our state called juries, who are the fact finders. They are incredibly savvy, and when they're presented with testimony that this bill is reasonable and testimony, no, it's not for whatever reason, it was too much treatment, it was too many times, whatever, that all goes in front of the jury and they're told you're the sole arbiters of the truth. You decide. You can award what they're asking, you can award more, you can award less, and they're really good at it.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. So let me tell you, last spring, after we adjourned, my wife had a health issue and went into Sinai Hospital for about nearly 2 weeks. We never got a bill. What I assume happened was Sinai prepared the bill and then went to my insurer, our insurer, which is Care First, and negotiated something, and then Care First paid Sinai the amount of the negotiated bill. Maybe the question is for you. I'm sorry, I forgot your name. No. You were just up there.
Sure, I'll stand back up here.
You're a trial lawyer, so this is a question for a trial lawyer. So we had the original bill, and then we had the amount that that was actually paid to Sinai after negotiating with Care First. So I've never been a personal injury lawyer, so I've never handled a personal injury case. But when you do a personal injury case, do you have to, as a plaintiff's lawyer, do you have to introduce the original bill? Or do you try to recover the amount that was actually paid?
That's a great question, and the answer is it depends on the type of case, because we have different rules in our state about different kinds of cases. So if it's a medical malpractice, a non-medical malpractice case, a car accident case, then you are allowed as the plaintiff to put in the full bill. In Maryland, we have the collateral source rule, which says that if you have insurance, disability coverage, whatever a collateral source is, you as a plaintiff are allowed to recover the full amount. And the tortfeasor, it doesn't get a credit for the fact that you contracted and paid health insurance premiums for your entire life. So in that kind of case, you can put in the full bill. And then you may have to, at the end of the case, pay back your health insurance company because they'll have a lien on what you recovered. In a medical malpractice case, there is a separate statute that's part of the Healthcare Malpractice Claims Act. In those cases, the plaintiff is allowed to put in the entire bill, but at the end of the case, there is a post-trial motion for remittitor to reduce it to only the amount paid. That's a special exception in medical malpractice cases.
Okay. And so the thrust of this bill is to try to obviate unnecessary testimony about the original bill, the higher bill, as rendered by the hospital or the care or the doctor.
Correct. We're trying to make it more efficient. We're trying not to waste juries and judges' time and our clients' money hiring the expert. We have this process in district court. There's a 10104, Courts and Judicial Proceedings 10104, which allows people to do this in district court as a cost and time-saving method. There's a jury instruction that juries are given in a circuit court case where they are told you can consider the bill as evidence, it's fair and reasonable, but we still have to prove it in circuit court. So in circuit court cases, we're trying to just say, no one is really disputing this issue, so we're not going to make the plaintiff come in and prove it, but we're going to preserve the defendant's right to object if they have some compelling reason why a bill is not reasonable.
Okay, and what, based on your experience, what percentage of the time would you estimate defense counsel tries to challenge the fairness and reasonableness of the bill that you're trying to introduce into evidence?
The vast majority of my cases are medical negligence and other catastrophic injury cases. I'll let Neil answer as to automobile world because he does much more of that. In my cases, every case that actually goes to trial, there is a challenge in some way, shape, or form that causes us to have to jump through these hoops.
Okay. And what, I guess, as a counterpart, in what percentage does the defense counsel successfully challenge the fairness and reasonableness of these bills?
None.
If they challenge them in almost every case, how often do they succeed?
None.
Okay. Could you answer the question for automobile cases?
So in car accident cases or in non-medical malpractice injury cases, what you have is cases are about all sorts of different things. So we can go to trial on a case where the injuries are clear and significant, but there's a dispute about liability, who ran the red light. And so the focus of the case is on that. There may be other cases where maybe liability isn't an issue, but there's a question of whether or not the injuries that the plaintiff is claiming were caused by the accident. And then there's this third category, and I'm speaking sort of broadly, of the fairness and reasonableness of bills, which is we're not disputing liability. We're not even disputing causation. What we're disputing is whether or not these bills that you're claiming were fair and reasonable. To answer your question very directly, it is an incredibly small percentage of cases, in my experience, from my understanding from speaking to colleagues, for their cases, in which that is the sole limited issue that is being addressed in a case. The overwhelming majority of cases involve causation or liability, and yet, as plaintiffs, we still currently have this affirmative obligation, even though nobody is disputing anything, to have to call an expert, pay money, have them testify. To accentuate a point made earlier, it can actually get it's even more significant than that, because sometimes you'll have plaintiffs and they'll have 3 or 4 or 5 different types of injuries. So you have 4 or 5 different experts, and an orthopedic expert can't testify to the fairness and reasonableness of a neurological expert. And so you may have a situation taken to the extreme where you have to call in 4 or 5 experts, pay them each separately solely to address this issue that nobody's disputing. It takes time, it costs money, and this bill takes off the table those situations where it's not an issue while preserving the defendant's ability to raise it when it is.
Thank you very much.
further, oh, Senator James.
Thank you. Just a couple of questions. Thank you, Senator, for your passionate presentation. But I'm just going to go over a couple of the things you mentioned, and then you all can follow up. I heard you say very emphatically that this bill is only about those who've been seriously injured. So I couldn't find that language in the statute, in the bill. So could you just direct me to where it says that this bill applies to only people that have been seriously injured?
Yes. So there is already a provision in the law when the claims are under $30,000, these bills are already coming in without the prerequisite of this establishing testimony. So the claim
Are
amount.
you talking about district court?
That's right.
Versus circuit court? Okay.
That as well. But yes, that's right.
So your statement is based on the fact that of the value of the claim of whether somebody's seriously injured or not?
That's right, Senator.
Okay. I did do a lot of automobile work as an early training in a large law firm. So I want to make one thing clear from at least the law and my own perspective and the ethics. The insurance companies were never my client. My client was somebody who bought insurance, and I was representing that individual. So in the sense that I have many constituents, some are, injured in an automobile accident, some are claimed to have caused the injury. Sometimes they look at each other and say they both caused the injury, but always, everybody in the case are individuals and constituents in my district, and I care about both of them. That's not an insurance company, it's not my client. So now I just want to ask another question about medical billing. Well, I would note we have an awful lot of fraud in the system lately, so it's hard to know what bills are legitimate or not. But this is my remembering of how medical bills look. And even in I haven't had one lately, but they're confusing. But I've received bills, and what you'll see is, a charge. Usually, to me, they're all too high. But then I see below that what my insurance will accept and pay, which is a different charge, and considerably lower. And somewhere in the middle is what actually might get paid, or less. Sometimes your insurance or the healthcare provider is a hard-charging type, and they want you to pay the difference. Sometimes, more often than not, I see healthcare providers of all stripes accept the insurance payment as opposed to the charge. So under your bill, your proposed bill, what medical bills would be introduced? Would they be the ones that first are issued by a healthcare provider, who, by the way, are not standardized in any way? Or is it the amount, the bill that the insurance company was willing to pay, or is it something else?
So if the bill has been paid, then they would introduce the bill as paid. Most often, the bill has not been paid, so they would be introducing the bill as not paid. Whatever version of the final billing statement they have is what they would introduce into evidence. What you noted is that the amount that's listed on the bill is derived from the charge master list. So every service, every fee, there's a list and a la carte menu of the fee for what it costs for performing that service. Now, we know here in the state of Maryland that we have our Health Services Commission that sets what the actual payments can be when you're having hospital care. And then you noted as well, if you're going to a doctor's office, then there's a different insurance rate that your insurance company will actually pay for the cost of the care that you receive. So you start off with that amount that's billed, that's based on the charge master list, and then if the claim has been paid, you'll have what your insurance company is willing to pay out on that claim. So they'll give the final billing into the record for the court's review, but ultimately it's at the discretion of the judge or the jury to decide what amount would be awarded for damages in any case.
I don't see that language that limits this. To me, the language is pretty clear that it's what the healthcare provider charged, right? Not a lower charge. So you would be amenable to us modifying it to reflect what you just said.
I don't understand the distinction you're making.
The bill as written says that, the medical bill is the document prepared by the healthcare provider, all right?
Okay.
It doesn't say that a lower amount was accepted as payment. It doesn't give any of those qualifications that you just mentioned. There's nowhere in here.
So to qualify under the bill, it has to be a bill that was provided in discovery. So in discovery is when the question would be asked about what was paid and what the bills were. So the discovery process is where you would get the final billing statement. So you can't enter the bills as with the presumption unless that bill was provided during discovery. And during discovery is where that qualification that you're looking for to make sure that the bill is the final rendering. If there was a payment made, what was paid, that's where that's going to be fleshed out.
We can go back. I think the bill would, I've done this for many, many decades. I think this needs to be modified to reflect what I think your intent is. I don't think it's crystal clear. And certainly, because you can always play, if I were a lawyer on the other side, I sure as heck would interpret this language to be the much higher cost in all cases, because I wouldn't see the qualification there. But that's not something we could sort out now. And I think there's one other comment.
Senator, there's someone else on the panel that would like to respond if you're open to an
Yes, I
additional
am.
reply.
That's great.
Thank
Thanks.
you.
Yeah, I think the disconnect is just that the bills that will come into evidence, if this bill is passed, the evidence that will come in at trial is exactly the same. This bill does not in any way, shape, or form change the piece of paper or the document that comes into evidence. So if it's an uninsured person that's never been paid, if it's an insured person, if it's Medicare, if it's Medicaid,
I understand
that still comes into evidence. And then whether there's an adjustment or a lien, it will happen after the trial is over.
And the last thing I wanted to bring up is I was a little unclear about the very strongly worded statement that this just shifts the burden so the defendant has to bring in the expert, not the plaintiff. That seems to presuppose that a plaintiff, once a defendant brought in an expert to challenge the bills, the plaintiff would throw up their hands and not hire an expert. To me, if you bring in an expert on the defense side and they do challenge the bills, what is the expectation of what the plaintiffs would do? Would they not hire an expert themselves?
If the defendant hired an expert to challenge the bills, the plaintiff could do the same. And ultimately, at the end of the day, as with every fact at a trial, it's up to the jury to decide. The plaintiff wouldn't have to. They could cross-examine the defense expert instead. They could make an argument to the jury in closing and say, don't believe what that person said. Whatever they wanted to do, they could do.
No, there were statements to the fact that this would just, all we would have is the defendant bringing an expert. It would completely alleviate the system and the plaintiffs from having to bring an expert as well. And I don't think the way the law works, that is not necessarily accurate.
Senator, can I address that for a brief second? I'll be very brief. And again, speaking solely from the perspective of doing auto accidents, which is mostly what I do, I think you're correct. I think the understanding and expectation would be that if a defendant rebutted the presumption, that the plaintiff would then be in a position of having to call an expert. Right. The purpose of this bill is to ensure that those cases are carved out, meaning instead of having to do it in every single case in which it's not an issue, that process would be reserved only for those small, limited number of cases where that dispute exists. So yes, there would be a battle of experts in those cases, right, but only those cases.
Right, but I didn't want the public at large to hear that this obviates the need for expert witnesses by both sides. That is not what the bill says, or not what it does.
I think the expectation would be in the cases in which it is an issue, there would be a battle of the experts, and it would mean that it would not be, in cases in which it was not an issue, it would be obviated.
Right, and in some of these cases, it's also the experts are needed for other things regarding the plaintiffs being able to prove their injuries, the nature of their injuries, the extent of their disability, their long-term. So there are going to be a lot of experts in a serious medical case, where there's injury.
Absolutely, and I think it's important to note that the causation element, which you, Senator, are referencing, this bill does nothing at all to affect that. The plaintiff still carries the burden of proving causation. This is purely
that might require some experts too.
It would require experts, but those experts wouldn't then have to go further. We wouldn't need separate experts to come in and have to talk about billing. Those, what you're describing as substantive, the plaintiff will always have the substantive burden on the procedural issues.
I don't think the bill obviates the need for medical experts for the plaintiff, though, either.
It would reduce it only to those cases where it was required. For billing, for the reasonable,
For
fairness of
billing,
reasonableness
yes,
of billing, yes.
but not for the injury. So,
Absolutely.
I'm sorry, there will be plenty of experts needed by the plaintiff, just not the billing expert.
Correct.
Potentially. All right,
Correct.
thank you,
Thank
Mr.
you.
Chairman.
All right, further questions from the committee? With that, that'll conclude the testimony for the proponents of the bill, and I'll switch to the opposition panel, and we'll hear from Mr. Enton, Mr. Wiggins, Bryson, Mr. Popham, and is Mr. Silverman. And Mr. Collins. And then Lauren Patron will just kind of rotate you in. You can pull up a chair as well, if we can help someone pull up a chair. And then is Ashlyn, oh, Gina, so Gina is also come on up. Stirred up a bee's nest with this one. Well, in opposition. All right. Go.
Good evening, Mr. Chairman and members of the committee. My name is Kerry Silverman, and I'm here today on behalf of the American Tort Reform Association to express our opposition to this bill. As others have discussed, this bill would establish a presumption in personal injury cases that charges that appear on medical bills are fair and reasonable. This presumption is inappropriate because it simply doesn't reflect reality. These are list prices that almost no one ever pays. Rather, just like when you buy a car and you go to the supermarket, it's the amount that's paid, not the sticker price, that represents the true value of a product or service. And this fact is even more pronounced in the medical billing context, where gross, standard, or charge master rates are often 3, 5, or 10 times the amount that healthcare providers customarily accept as payment, regardless of who is going to pay. Look, in Maryland, plaintiffs' lawyers and proponents have recognized this already can and do introduce the medical bills, including the full charges, even if no one paid that amount. Defendants can't introduce the amounts that are actually paid, which isn't the case in some other states. And plaintiffs, due to the collateral source rule, still get their damages covered even if insurance covered those costs. But what this bill does is make it even harder for defendants in this pro-plaintiff context to challenge the charges as reasonable, as whether they are reasonable. As you consider this bill, the committee should be aware that it goes in precisely the opposite direction of what we're seeing in other states across the country. At least 10 states in state legislatures, 7 since 2020, have adopted laws recognizing that the amounts paid for care, not the fictional billed amounts, are never collected, and it's those amounts that are paid that reflect the value of medical treatment. Other states take this approach as a result of court rulings, as in California. So what this bill does is make what is already a plaintiff-friendly environment even worse by placing the burden on the defendants to prove that bills that are not reasonable are unreasonable. Thank you. I welcome your questions. Thank you.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Carville Collins on behalf of Maryland Employers for Civil Justice Reform Coalition. We're here in opposition. We are comprised of many of the largest employers, businesses, and healthcare providers in Maryland. Mr. Silverman has explained our current system very well. Maryland recognizes that the correct and reasonable value of medical treatment is the amount actually paid and approved by a healthcare provider, not an inflated price that could appear on a medical bill for that treatment that is almost never actually paid. And it is, in fact, the difference between the sticker price and the actual price paid. Prices in the charge master that has been explained by the proponents serve as the starting point for negotiations with insurance providers. These negotiated rates determine what is actually reimbursed to the healthcare provider and therefore represent what is actually paid by the patient. Our concern with the bill is this. To maximize damage awards, the proponents, by the way, all plaintiffs' lawyers, seek to use the amounts billed, the sticker prices, to support their claims for damages. At the same time, the bill seeks to protect these inflated damage claims by switching the burden of proof from the plaintiff to the defendant. These overstatements of cost and the additional defense costs will necessarily enlarge verdicts and therefore increase costs. Increase costs to consumers of liability insurance, and they'll increase costs to defendants to rebut the pricing contained in medical bills. And as the fiscal note clearly explains, those defendants facing higher costs include the state of Maryland, include county governments. Eventually, all these costs will be borne by consumers and taxpayers. For that reason, we are urging an unfavorable report. Thank you.
Mr. Chairman, members of the committee, Bryson Popp, I'm appearing on behalf of the Maryland Association of Mutual Insurance Companies, which is a trade association of 12 insurance companies, some of which are located in Maryland. Hartford Mutual is one of them. One of them, in full disclosure, is a medical malpractice insurer that is Medical Mutual. You all are familiar with that. In respectful opposition to this legislation. My testimony is very brief. You can refer to my written testimony, but I'll just make 3 points. One is this does turn the fundamental operation of litigation in our system on its head, because for the first time, it is not the plaintiff who has to prove the claim under this bill. The defendant has to disprove the claim. It does shift the burden in that way. And there's no real reason for doing that. When I listened carefully to the proponents panel, I didn't hear any terribly burdensome obstacle to them proving their claim. That's the way our system works. With respect to the insurance costs, I have no idea how much this is going to affect insurance costs, but I do know this: if you shift at the cost of an important function, like an expert testimony that's contracted for by a party, from the plaintiff to the defendant, that's going to go into future insurance rates. I'm not going to say that it'll increase them a great deal, but it will have an effect on it. And we have many, many effects that we are dealing with now on insurance. We have a lot of other problems we have to deal with here. In short, I didn't hear a particular need to justify this bill. And the last point I want to make is, if you look at the language of the bill, it isn't just the healthcare provider's medical charges, it's the agent of the healthcare. I keep staring at that, wondering, who is that person? For those reasons, Mr. Chairman, members of the committee, I respectfully request an unfavorable report.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Lauren Packman, and I am Legislative and Regulatory Senior Counsel for Allstate in the state of Maryland. Thank you for the opportunity to speak today. I'm here to speak in opposition to SB 269. I want to just deviate from what I had prepared to address some of the items that I heard spoken of during the proponents' time. The first is that the bill text does not specify that it's only the most severely injured, as Senator James mentioned. Also, generally speaking, and I've been both a plaintiff's attorney and a defense attorney, so I can tell you, most of the time plaintiff's attorneys are going to call first and foremost treating medical providers and or hospital folks who work in the facility where the person was treated. And those people are fact witnesses. They're not expert witnesses. They don't cost the amount of money and preparation that expert witnesses cost plaintiffs or defendants, for that matter, to do. The other thing is that the sponsor, Senator Henson, I think, said something that implied that these shifts of burden would only occur after the issue of liability is already decided. That's not in the bill. If that's the case, that's a different bill. That's something I would have to take back to my folks, but that is not what is in the bill. The bill does not do anything, as someone else said in favor of the bill, as someone else said, it doesn't change liability, meaning that it keeps liability the same. So it does not come into effect only after liability has already been decided that the defendants at issue are liable, in fact, for the injuries caused. The other thing is that the plaintiffs in general do not make their clients pay out of pocket for medical experts or any other expenses. Also, I just want to add, I see my time is running out, this undermines the role of the jury in the judicial process by effectively instructing the jury what they should think about the medical bills rather than allowing the jury to use their own discretion. And if the juries are as well versed as the proponents say they are, and I believe that they are, they can be entrusted with that. Thank you.
Good afternoon, Mr. Chair and members of the committee. Thank you for the opportunity to speak today. My name is Gina Rotuno, and on behalf of the National Association of Mutual Insurance Companies, we most respectfully oppose Senate Bill 269. This bill shifts the burden of proof to the defense by creating a presumption of reasonableness for medical expenses. And as written, the bill requires defendants to overcome that presumption and to bear all associated costs in doing so. Traditionally, under common law and established litigation principles, plaintiffs must prove their damages and demonstrate that those damages are reasonable. The burden appropriately rests with the plaintiff because they are the party bringing the claim and they possess the evidence to support it. By establishing a presumption of reasonableness, Senate Bill 269 removes this burden from plaintiffs and forces defendants to disprove the necessity of the claimed expenses. Defendants should only be responsible for paying reasonable expenses that are directly related to and caused by the incident in question. Passage of SB 269 is likely to increase litigation costs. That could ultimately raise the average cost of claims, putting upward pressure on insurance rates. For these reasons, we respectfully oppose Senate Bill 269.
Mr. Chairman, members of the committee, Robert Etton on behalf of the American Property Casualty Insurers Association. We're very, very much opposed to this legislation with all due respect to the sponsor. Let me just say that all you need to do is look at the explanation of benefits for the last time you had any treatment by a physician or by a hospital. I was just looking at mine. Have a charge, the physician charge was $6,665. The carrier paid $2,845. Now, I can't think, and I know that the sponsor said that, I guess in claims of discrimination, the burden shifts to the party accused of discriminating. But I've been a lawyer for, I don't know, 50 years, whatever. I've never seen a situation in my practice at all where the burden to prove damages shifted to the defendant. It just doesn't do that. I mean, they're the claimant. They're going to make the claim, and it's up to them to prove to the judge, to the jury, whoever it is, that that's the right amount. And whether the lawyers for the plaintiffs don't like it because it's a pain in the you-know-what, it goes with the territory. And it's not a reason to pass this bill. So with all due respect, we'd ask for an unfavorable report. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. Amongst our 7,000 business members, we have many law firms that provide services both on the plaintiff and defense side of personal injury law. And when we consider the facts around this bill and when we listen to the testimony, the Chamber's position is that ultimately this bill, the effect of it will reverberate across the state and make Maryland less affordable and further exacerbate our slow economic growth for many of the reasons you've heard from this panel. And I would just note that, we were very encouraged by the Senate Democratic caucuses, two of their primary goals this year being economic growth and affordability. And so to the extent that this bill makes Maryland less affordable and slows our economic growth, it would be out of alignment with those priorities. And for those reasons, we're opposed to the bill. Thank you, Mr. Chair.
Thank you, Mr. Chair. Let me go back, and I'm not sure who to address this question to, so you fight amongst who has the chance to respond to me. Let me go back to my wife's situation last spring. Let's assume that the reason she was in the hospital was because someone hit her, and she was not at fault. The other driver was at fault. And so she's in the hospital, and she comes out after the better part of 2 weeks in the hospital, and we want to engage a lawyer to sue the person who hit her and to recover not only the medical expenses, but also pain and suffering. So this bill is all about the medical expenses. And I think I understood from the proponents of the bill that what would happen is that the lawyer representing us would try to introduce into evidence the original bills, not the amount that she actually paid after negotiation with Care First, but the original bills at the top level. And then after we got a judgment, there would be a remitter. The court would, on its own, I guess based on request, enter a remitter to reduce the amount of the final judgment down to reflect the actual amount of money that the insurance company paid. Is that correct? Now, one of you can answer the question.
Well, let me go back. My understanding, Senator, is that what would be introduced are the billed amounts, the higher the charge master rates, and that's all the jury would typically see. They would not see.
They would not see how much
was actually paid. Not in the state of Maryland. That is the case in some other states. They would, not in Maryland. So they would make their verdict based on the billed rates, which could be challenged, but they could not see the amounts that are paid, is my understanding. Now, the set-off that you mentioned, that only happens, as the proponents pointed out, in the medical malpractice context. There's no reduction in a general personal injury, auto accident, slip and fall case based on the amounts that are actually accepted, not
So let me get this straight. So if my wife goes to the hospital because somebody hit her, and let's assume the actual medicals for 2 weeks in the hospital are $100,000, and Care First negotiated that down to $50,000. Care First paid $50,000. So our attorney is going to introduce medical bills for $100,000, and defense counsel is not permitted to tell the jury that that's not what was paid?
That is my understanding under the collateral source rule in Maryland, that anything related to insurance coverage can't be introduced.
So the jury, if they want to award my wife the full medicals reflecting her medical injuries, is going to award my wife $100,000, even though Sinai Hospital was only paid $50,000 by Care First.
The plaintiff can seek that full amount, and this bill puts in a presumption that not only that amount is a reasonable and fair amount. Yes.
Okay. Well, I guess I'm happy I wasn't a plaintiff's lawyer. Yeah, right.
I just wanted to add a couple of things, which are that I think one of the proponents mentioned something about like the insurance company could potentially put a lien on the award after the fact, so that may be at issue. I haven't practiced in Maryland in a long time, so I don't want to speak beyond my knowledge. The other thing I wanted to point out, though, is that with a presumption that the bills are valid, there's no one to cross-examine from the defense. Like, the defense attorney cannot cross-examine the pieces of paper that represent the presumed valid, fair, and reasonable bills.
But the defense attorney can't cross-examine the person trying to get the evidence into evidence.
They could.
On the basis that this is not the amount that was actually paid to the hospital.
They couldn't. I don't think the cross-examination could include that in its scope, what was actually paid, but they could certainly inquire as to whether the medical bills are authentic, whether the charges are fair and reasonable for the services provided, whether they're in keeping with their usual charges for those same services. There are things that can be done when there's an opportunity to cross-examine. When there's no opportunity to cross-examine, the whole line of questioning is foreclosed upon.
Last question, if I could. The proponents said that defense counsel frequently challenged the fairness and reasonableness of the bills, but almost never succeed. Do you all agree that that's the case?
I don't know that, with all due respect, I don't know if that's what I heard them say. To me, it sounded like they were saying they were almost never challenged.
Oh, I thought I heard them say they're challenged all the time.
Oh,
But the challengers almost never succeed in preventing the evidence from coming into evidence.
I mean, in my limited experience, I would just say that in general, most of the time, both sides have bigger fish to fry than the authenticity of the medical bills. The reasonableness of the
I would think the fairness and reasonableness would
charges
be more
may
significant than
be a different
authenticity. Yeah.
issue, right? And that's something that I think defense attorneys would argue about if they had the opportunity. But again, you can't cross-examine a piece of paper, so it's unclear how they would do that if this bill passes.
Okay. Thank you very much.
Thanks.
Before you switch over, so just while you're up there, ma'am, I mean, so fairness and reasonableness of the fee, but you cannot challenge the actual amount paid.
My understanding is that if there's a discrepancy between the amount charged and the amount paid, that the amount paid by insurance is not admissible in Maryland, right? That's my understanding of it, right? So
I want to just if you could just I want to make sure that's clear for people trying to understand the impact of the bill.
That's my understanding, yes.
All right, Senator Henson.
Chairman, I apologize. I did not record your name. Mr. Silverman, may I ask you a question, please? Mr. Silverman, you described Maryland as a plaintiff-friendly state, did you not?
I did.
You did. And you're familiar with contributory negligence, correct?
Yes, I am.
And that's a doctrine where if you're even 1% at fault, you are barred from recovery, correct?
Well, with exceptions, but yes.
And Maryland is one of only a handful of states that cling to contributory negligence, correct?
That is true, Senator.
So what we would be doing is, I guess we're talking about, and even to get to the point where this bill would impact your life, you have to be pretty much a perfect victim who have found yourself injured and have not contributed to that injury. You have to find yourself in the circumstances where you could even access relief in the state of Maryland, which has put up a barrier to being able to do so. Is that correct?
I think, as you said, Senator, there are two different parts of determining liability. There's a liability phase and a damages phase, and yes, in this case, we're talking about damages. So that's accurate. They're not separate phases. There's no mandatory bifurcation or anything like that in Maryland. But yes, and we're dealing here with someone who has gotten to the damages portion. There's been liability, and so.
And then further, when we're talking about what you can get after you've been injured, we've limited as well non-economic damages. We have a cap on those in the state of Maryland, correct?
That is correct.
And the non-economic damages in states that don't have caps, that's where you really recover those large dollars, correct?
Can be. It can be.
And one of the reasons we limit it is, I guess, the request, the advocacy of groups such as yours, so that the industry wouldn't have to absorb the high cost of having to pay out claims that included large dollar amounts of non-economic damages. Is that correct?
That's correct. My comments on the plaintiff friendliness of Maryland were related to the collateral source rule, which you have and some other states have abrogated and allow set-offs of damages.
I think I understood.
And they're on the billed and unpaid amounts, where many states have moved in the opposite of direction of what you're considering.
I think I understood.
Your comments are well taken.
I appreciate it. Mr. Wiggins? Sir, you mentioned uplifting our affordability agenda, and it is always so good to hear those agendas echoed and repeated. How specifically? Because even our fiscal note drafters, it's an interesting fiscal note because it doesn't have any numbers in it. So if you have found a way to quantify how this will increase costs and how this will drift us from affordability, I would love to know specifically what dollar amounts this is going to add to the cost of claims in Maryland, because even the experts who draft these fiscal notes had no dollar amounts to add to that.
Sure, I appreciate the question. So the first I would point to the small business effect, which notice would be meaningful.
I'm sorry, was there a dollar amount?
Are you looking for a specific dollar amount
I am.
per item sold, or?
Your claim was that we have an affordability agenda and that this bill single-handedly is going to run afoul of our affordability agenda. So I would just like to understand that, because I support the affordability agenda and I certainly would not want to do anything that runs afoul of our affordability agenda. It is core to me as a legislator, and it is certainly essential to the folks who are in my district who want to make sure that I have policies that are aligned with it. So your statements were that this bill was not in alignment with that affordability agenda. So if I'm going to take a second look at this bill, I want to understand specifically how you're coming to that conclusion and to what degree it is out of alignment with the affordability agenda. And that's hard to do without numbers. So you made a bold statement, so I assume there were numbers there that supported that.
Certainly. So one, I think the proponent's testimony made that case for me. I mean, they noted the price of experts to challenge, and this would be shifted to the defendant, small businesses, which are going to have to pay that out of pocket. That's going to increase the cost of doing business, which is going to increase the cost of the goods and services they provide. So I think they made that case for me. But we talk about maximizing damage awards and larger verdicts. That all contributes to the price of doing business in Maryland. And we're already 46th as a state in tax climate. I mean, we're not creating new businesses. We have slow economic growth.
Where does this add to taxes? And I did not hear from the proponents of the bill.
It's a larger atmosphere.
I did not hear from the proponents of the bill that the cost of incurring expert testimony was going to happen differently. What I heard and fleshed out through the questions of my colleague is that experts are hired now and experts would be hired if the bill passes. That happens, that's a part of trials and litigation, that there's experts that are sometimes hired for dual purposes as fact witnesses, and then experts that are hired to talk about these bills, and that it would be happening whether you have a battle of the experts or whether you're bringing the experts in on the defense side of the cases. And again, if you could get back to me offline with specific dollar amounts, when you make a claim that this bill is not going to be in alignment with the affordability agenda, something that's essential to the work that we're doing here, it would be great to support that with figures that show how out of alignment it is, so that I could make sure as a legislator that I'm holding tight to those values and principles. So what I heard them say is that experts are hired and that they would continue to be hired if the bill were passed.
I'm certainly happy at your request to follow up offline. Again, though, I would just note, when you're setting up a system that creates a prima facie dynamic where you are going to have businesses having to challenge these bills, and the proponents talk about the resources involved with that, I don't know how that doesn't increase the cost of doing business.
What I heard them say is that people hire experts now and that people would be hiring experts if the bill passed as well. What I heard them say is that often there are experts who are there already at trial when they are challenging and or establishing facts, and so they would continue to do that. So I certainly would look forward to the figures that support that this bill specifically would be out of alignment with affordability. I know that sometimes when we get testimony, the testimony will say, we had a bill 2 or 3 bills before this, and the witness said, this will increase premiums for condo insurance fees by $8, and they were able to quantify for us how specifically it would do that. If you're going to make a claim that says it's out of alignment with affordability, I would just appreciate some data to say how much, because perhaps that would change my support for the bill if I understood how specifically it was going to do that.
Senator Henson, I appreciate the request. I will follow up with you. I will leave the condo bills to y'all.
Thank you. I appreciate that. That is fantastic. Thank you. Thank you, Mr. Chair.
All right, further questions from the committee? Excellent, thank you all very much. All right, with that, that will conclude the hearing for Senate Bill 269. We'll now move on to Senator Sidnor with Senate Bill 274.
right. Senator Charles Sidnor testifying on behalf of Senate Bill 274. Before I get into the written testimony, I wanted to just level set. On April 23rd, President Donald Trump issued Executive Order 14281, restoring equality of opportunity and meritocracy. Within that executive order, the president claims that, and I will quote, disparate impact liability imperils the effectiveness of civil rights laws by mandating rather than prescribing discrimination. As the Supreme Court put it, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Disparate impact liability is wholly inconsistent with the Constitution and threatens the commitment to merit and equality of opportunity that forms the foundation of the American dream. Close quote. All of that is from his executive order. But I'm here to say that the disparate impact discrimination theory was first recognized by the United States Supreme Court in Griggs versus Duke Power Company. This is in 1971, when analyzing Title VII of the Civil Rights Act of 1964. Disparate impact claims have thereafter been allowed under the Age Discrimination in Employment Act, the Americans with Disabilities Act, and most relevant to the matter we have at hand today, the Fair Housing Act. In fact, in its 2015 Supreme Court case, Texas Department of Housing and Community Affairs versus Inclusive Communities Project, our court said, in light of the longstanding judicial interpretation of the FHA to encompass disparate impact claims and congressional reaffirmation of that result, residents and policymakers have come to rely on the availability of disparate impact claims. Indeed, many of our nation's largest cities, entities that are potential defendants in disparate impact suits have submitted an amicus brief in the case supporting disparate impact liability under the FHA. The existence of disparate impact liability in the substance and in the substantial majority of the courts of appeals for the last several decades has not given rise to dire consequences. Level set. So, as the current federal administration attempts to end fair housing protections, it is more important than ever to provide explicit remedies in discrimination or to discrimination in housing. Last July, following a federal executive order that I just talked about, where he denounced disparate impact litigation, ProPublica reported that the U.S. Department of Housing and Urban Development planned to drop 7 major housing discrimination cases. Some of these investigations had already formally found instances of discrimination. All of them have been made claims of disparate impact discrimination. As the Maryland Supreme Court wrote in its 2024 case, Hare versus David S. Brown Enterprises, disparate impact theory recognizes that at times, treating things that are different in meaningful ways as though they are the same can perpetuate discrimination. Disparate impact discrimination does not require an individual or an entity to intend to discriminate. Rather, it uses apparently neutral practices to freeze the status quo of the prior discriminatory practices. Senate Bill 274 codifies in Maryland law the protection against housing discrimination in the Fair Housing Act and has been affirmed in both federal and state courts since its passage. The protections SB 274 provides against disparate impact discrimination mirror the protections established in federal and state cases interpreting the Fair Housing Act. Disparate impact discrimination occurs when a policy or practice disproportionately harms a protected class and there is either no legitimate reason for that policy or practice or another policy or practice that would achieve the same goals without causing harm. First, this bill explicitly empowers our Department of Housing and Community Development to issue regulations to ensure that our affirmatively furthering fair housing law that was passed just a few years ago has the framework that is needed. It defines discriminatory effect as an effect that actually or predictably has a disparate impact on a group of people based on the number of protected classes and clarifies that Maryland prohibits disparate impact discrimination in housing. Section 20-705A states that intent is irrelevant to determining whether discrimination took place, and adds a provision to recognize instances of discrimination that do not fall neatly into the already listed categories. Finally, 20-705B allows a person who is accused of disparate impact discrimination to prove that even if their conduct had a disparate impact on a protected class, that practices were not intended to discriminate or achieve a substantial legitimate or non-discriminatory legitimate goal, or the only way to achieve that acceptable goal. If they prove those three things, they may be found not to have violated this particular statute. So Senate Bill 274, it simply enshrines fair housing protections for Marylanders and provides the tools for individuals and localities to pursue justice in housing. And with that, I ask for a favorable report on Senate Bill 274. Thank you.
All right. Good evening, Chair, Vice Chair, members of the committee. My name is David Wheaton. I'm an attorney with the Legal Defense Fund, founded by Thurgood Marshall in 1940. LDF is the nation's oldest racial justice legal organization. And I'm here today in support of Maryland Senate Bill 274, which would strengthen state fair housing laws and provide guidance to Maryland cities, counties, and housing authorities on proactive steps to combat housing discrimination and overcome patterns of housing segregation. LDF urges a favorable report out of committee. Every Marylander should have access to safe, affordable, and accessible housing in thriving neighborhoods free from discrimination. Unfortunately, the Trump administration has rolled back key federal regulations that prevent housing discrimination and encourage local housing authorities to create thriving neighborhoods for all people. HUD's decision to roll back its disparate impact regulations that are designed to help enforce the law makes it more difficult for marginalized communities to address systemic housing discrimination and leaves them vulnerable during a fair and affordable housing crisis. Also, HUD's decision to weaken its affirmatively furthering fair housing rules deprives local governments of meaningful planning tools needed to identify and address fair housing challenges. SB 274 pushes back against the Trump administration's blatant attempt to undermine housing discrimination and weaken regulations related to reducing housing segregation. SB 274 explicitly codifies the disparate impact liability into state law, and additionally, SB 274 allows for DHCD to issue regulations related to AFFH, or affirmatively furthering fair housing, filling the gap left by the Trump administration's weakened affirmatively fair housing rules. SB 274 will help remedy decades-long exclusion of Black residents and other residents of color, people with disabilities, and other protected classes who have experienced historic and present-day discrimination. The legislation will also help ensure that there are fair and affordable housing opportunities and stronger and more viable neighborhoods for Black residents and members of other protected classes. We urge a favorable report out of committee. Thank you so much.
Good evening, Honorable Chair, committee members. Thank you, Senator Sidner, for introducing this bill and inviting our comments. My name is Leanne Rosenberg, and I'm the Deputy Advocacy Director of the Tenant Right to Counsel Project at Maryland Legal Aid. As you can imagine, much of my current work focuses on ensuring that many of our most vulnerable neighbors and community members are able to get and keep a place to call home. Our clients often encounter significant challenges to finding affordable housing. Many of our clients live in low-income communities throughout Maryland, communities that continue to be impacted by the legacy of discrimination that was previously enshrined in our laws, discrimination that persists despite our existing fair housing laws. In addition to my current role, I also have experience handling civil rights cases on behalf of the United States at the Department of Justice. From both my present and prior vantage points, I have seen the importance of ensuring that we maintain and properly exercise our existing tools for protecting and guaranteeing basic civil rights. Senate Bill 274 is an opportunity for Maryland to do just that, and to do so at a critical moment. This bill affirms our commitment to eliminating discrimination, root and branch, in our housing market. It would enshrine fair housing principles in our laws, principles that were endorsed by the Supreme Court of Maryland just last year. SB 274 would make clear to all Marylanders that in our state, they have the right to call out and seek an end to processes and policies that have a discriminatory effect. SB 274 also builds on the important work that the General Assembly put in motion in 2021. DHCD is already deeply engaged with local jurisdictions on their obligation to affirmatively further fair housing, which is to take meaningful actions to combat segregation and expand pathways to housing and economic opportunity. This bill ensures that DHCD can issue regulations and promulgate guidance that furthers that important work. This is an urgent moment for Maryland to make clear that it is staying the course on longstanding civil rights laws. Maryland Legal Aid believes that it is in all our interests to pass SB 274 and ensure fair housing for all Marylanders. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Jennifer Bevan Dangle. I'm the Deputy Director of Economic Action Maryland Fund. On behalf of our subscribers, our clients, and our partners, we're very proud to stand here and support this legislation. It is important to keep in mind that coming out of sort of the weeds of this bill, that this legislation does two important things. One, it puts back in place in Maryland effectively Obama-era guidelines that were in place for many, many years. So this is not uncharted territory. This is simply restoring protections to Marylanders that they had previously enjoyed and perhaps even begun to take for granted. We know that nationwide, the discrimination complaints are rising. We see that with our own fair housing outreach program. But because, as the Senator mentioned, because of the lack of enforcement, the cuts to the budget, and the rollback of regulations at the federal level, proper enforcement of these complaints is decreasing just as we're seeing these complaints rise. In our own work, we're seeing numerous increases in complaints, especially around disability, source of income. These are very real things that, as you've heard from legal aid, are affecting clients and tenants across Maryland. The legislation also mostly aligns with several states, including those surrounding us: New York, New Jersey, Illinois, Minnesota, Colorado, California, the last ones being more far spread. But again, this is not uncharted territory. This is not some new lift. This is restoring protections to Marylanders that they need, that they deserve, and that perhaps we all started to take for granted. The advocates have reviewed the amendments put in by the housing providers. We do have serious concerns, especially striking some of the intent language we feel would significantly weaken the intent of the bill. And so we look forward to working with the committee to mitigate the amendment process and make sure that the bill is not overly weakened through that work. And with that, we urge a favorable report. Thank you.
All right, I have Albert Turner signed up.
He had to leave, unfortunately.
Okay, excellent. All right, so we'll turn it over for questions, and we'll move over to the favorable with amendments. Senator West.
Mr. Chair, so the bill sounds great, but the language is very broad. It's not specific. It basically states principles. And so I'm trying to apply it to specifics. Let me give you a specific situation. In Baltimore County, we have had for generations something we call the URDL, Urban-Rural Demarcation Line, which separates the developed part of Baltimore County from North County. We want to keep North County rural, largely agricultural, to preserve those Baltimore County traditions of farming, primarily farming, and the farming families up there. The Hereford High School, I just had a shadow today from the Hereford High School, who lives up in the Hereford zone. We even call it the Hereford zone because it's so different from the rest of Baltimore County. It gets cold, it gets icy up there, it gets snowy up there. So suppose a member of the Baltimore County Council were to propose terminating the URDL line and opening up Baltimore County to development and rezoning northern Baltimore County for multifamily housing. And the other members of the county council were to say, no, we're not going to do this. Under this bill, the broad general language of this bill, could the members of the Baltimore County Council who refused to rezone northern Baltimore County for multifamily housing, could they be sued by an individual under section 20-1035 of the bill and taken to court for having violated, if we pass the bill, for having violated this law?
So thank you for your question, Senator. I want to say first on the AFFH portion of this and the further fair housing, one of the good things and great things about that is it allows for a community process. And so there would be community input to whatever plan, fair housing plan that we maybe put into place. And so I think that would allow for the differences of opinions between North Baltimore County and South Baltimore County to kind of flesh itself out. On the particulars of whether somebody could be sued under desperate impact liability under that specific, there is a burden shifting test that would have to happen. So that plaintiff would have to use statistical evidence, a desperate impact analysis to maybe show that whatever zoning laws are disproportionately excluding maybe certain members of a protected class. But then that property owner or the other entity, whoever's being sued, would then get to kind of have the burden to come back to see if there was another less discriminatory alternative. And so I think that would hopefully ensure that there wouldn't be just somebody being sued simply because like statistical evidence, but it allows the burden shifter to go back to the defendant to show that there was a sufficient cause. So if the folks of North Baltimore County wanted to give some specific reasons of why they wanted to keep it agricultural, they'd be able to show that evidence. And so that's kind of where the burden shifting framework goes on desperate impact liability.
So as I understand your testimony, if we pass this bill and a member of the Baltimore County Council proposed getting rid of the Erdel line and rezoning all of northern Baltimore County for multifamily housing, and that was defeated, the members of the county council who voted against it could indeed be sued under this bill and would have to be involved in a piece of litigation in which they defended their action by this burden shifting analysis in which they could lose. Baltimore County would then be developed intensively, and what would happen to them if they lost the lawsuit? Is it criminal liability or civil liability or what?
No, right now it would be more on the civil liability, but there's usually what there are in these types of disparate impact cases. There's usually like some type of settlement or negotiated settlement where I think Baltimore County has had some of these particular settlements where they would say, hey, you have to build a certain amount of units, particularly in maybe a certain area, so that you are giving people choice. Again, disparate impact and AFFH about ensuring that all people, no matter regardless of your income, have choices and opportunities to live throughout the state of Maryland. And so that, hopefully that answers your question.
So in a way, but this, I asked my question specifically about Baltimore County, but the same question, I guess, could be asked about any part of the state that's agricultural and where the zoning is agricultural zoning. If someone proposes to change that zoning to intensive multifamily housing development and it gets rejected, whether it's the county commissioners, the county council, whoever rejects that could be sued under this bill and taken to court for having engaged in discrimination and would have to defend themselves in court, might win the case, but might lose the case, correct?
Very theoretically, yes. The plaintiffs would have to have a lot of statistical evidence to even, again, meet that first criteria. And so
what is that criteria they would need the evidence to get past? I'm sorry.
Yeah, just to have some type of discriminatory effect.
Well, based on the definition of discrimination here, if you can establish that minorities are more heavily concentrated in multifamily housing, I think it'd be pretty simple to establish that a vote to deny multifamily housing in agricultural areas indeed had discriminatory effect. Wouldn't that be the case?
Yeah.
Senator, again, this statute, this bill is only attempting to put into statute what is currently the law. And I don't think that type of lawsuit has happened in Baltimore County. What Baltimore County has been sued for is not providing enough affordable housing. That's why we're under the conciliatory agreement. But I don't think there's been a suit under the Fair Housing Act towards the Erdel. Although I think if you look at the history of the Irritable people, I'm not going to go there. I'll leave that alone.
I thank you for that, Senator. I'm one of these plain language guys who reads the plain language and figures that that's the way the courts will enforce a bill. And the plain language here is really general.
Are you talking about the definition of discriminatory effect? Or which language are you talking about?
Well, the definition of discriminatory effect is general, and then the operative language later on that says a person hasn't violated a prohibition if, and again, it's pretty general as to, it says the person could not have achieved the substantial, legitimate, and non-discriminatory interest by less discriminatory means. My guess is people who are county councilmen, county commissioners are not going to want to be the subject of discrimination cases, which are going to involve lots of legal resources and lots of time, as well as reputational damage.
Again, Senator, this is like just codifying what is already in statute and what is already in law. So the definition of discriminatory effect that you were saying, it was found in the Inclusive Communities Project, and so was that burden shifting language. And so we are simply just codifying what the regulations put forth and what Inclusive Communities Project put forth. So we are just codifying that. So there's no new law or no new standard that we are putting forth here today. And so in your hypothetical, a sitting person could be sued for that currently right now under current fair housing law, both state because of the Hare decision and federal.
All right, I guess last question. If this bill merely puts into effect what's the existing law, why do we need the bill?
If I may, and first, of course, I'd be remiss if I didn't say thank you for all your work on the ACE bill. What's necessary here is putting into place a clear statement of law for the state of Maryland because the federal landscape is shifting. The definition of discriminatory effect is that which is in the Fair Housing Act, and the test, the three-part, what constitutes disparate impact, that standard comes directly from the application that the Supreme Court of Maryland put forth in Hare just last year. The reason why it's necessary is Marylanders need clarity in this moment. The federal government is attempting to roll back places where people can seek relief, the Civil Rights Division of the Department of Justice, the Department of Housing and Urban Development. Those agencies are walking away from civil rights enforcement, and it's really important that Marylanders know that we are not, that we have laws that are clear and straightforward that say, this is what your potential causes of action are. In this case, it's disparate impact theory. And rather than having to comb through a Supreme Court decision that may not make sense to a lot of people, we are clearly here today saying that is what the law is. The legislature is agreeing with the judiciary. That's a valid cause of action. It exists here in Maryland. If this happens to you, we will take action to help you protect your rights.
Thank you for your answer.
And Senator West, I don't know if you happened to see it, but just over the past couple of weeks, the Secretary of HUD had an opportunity to visit Capitol Hill and was questioned by Congressman Al Green about disparate impact theory. And he asked him a very plain question about whether or not housing discrimination still exists today. And unfortunately, our secretary hemmed and hawed and didn't want to answer that question until it was asked multiple times. And then what he said was that they're going to enforce real discrimination. So what our panel is talking about, us codifying the president, again, with this executive order that I noted, he's attempting to move the goalposts. The law is the law. At the federal level, the HUD secretary has made it very clear that they don't want to enforce fair housing laws. They're pulling back funding so that those who are doing the test and doing the work aren't going to have the resources. So what this is a statement here in Maryland. We're going to codify what the law is because we're going to protect Marylanders and make certain that the laws that they had protecting us for all these years is going to be permanent here in the state.
Excellent. Thank you very much. No further questions from the committee for the proponents of the bill. We'll now switch over to the favorable with amendments. And Gina Rotuno, Gina, welcome. And then Hugo Cantu. Oh, that's you. Okay. Ryan, come on up.
All right, good evening, Mr. Chair and members of the committee. Thank you for the opportunity to speak today. My name is Gina, and again, I'm here on behalf of the National Association of Mutual Insurance Companies, and I appreciate the opportunity to offer testimony in favor of Senate Bill 274 with amendments. NAMIC strongly supports the General Assembly's efforts to strengthen fair housing protections and ensure everyone has meaningful access to housing opportunities, and appreciates the intent of the bill. As written, the bill's prohibition on actions with a discriminatory effect could unintentionally extend to homeowners insurance. Because this bill applies to services connected with the sale or rental of housing, it risks creating conflicting standards with the Maryland Insurance Article's existing Unfair Trade Practices Act. Homeowners insurance underwriting is already highly regulated by a well-established framework under the Unfair Trade Practices Act, which prohibits insurers from refusing to issue a policy for any arbitrary, capricious, or unfairly discriminatory reason, regardless of intent. This longstanding standard has been carefully developed and enforced by the Maryland Insurance Administration. We're just asking to avoid any sort of overlap or inconsistencies. We respectfully request an amendment really just clarifying that insurance underwriting decisions remain governed exclusively by the standards and enforcement mechanisms already in place and established. We have draft amendment language in it that accomplishes this while still fully preserving the bill's fair housing goals. We'd be happy to share this amendment with language with the committee and work with the sponsor and his team to ensure the legislation's intent is met without any sort of unintended hiccups or consequences. Thank you for your time and your consideration.
Good afternoon, Mr. Chair, members of the committee. Brian Anley with the Apartment and Office Building Association. You all have written testimony from AYOBA and also the Maryland Multi-Housing Association. It's a joint written testimony. As Senator West noted, we believe that the bill is drafted overly broad, and there appear to be a few contradictions, specifically the use of intent. On the one hand, it says that a housing provider can be found in violation of fair housing laws, regardless of whether that was the intent or not. On the other, it says that it is not a violation if there was no discriminatory intent, or if the business interests could be achieved by less discriminatory means. To correct that, we ask that the term regardless of intent be stricken from the bill. And then second, the bill defines discriminatory effect as an action that increases, reinforces, or perpetuates segregated housing patterns. As the chair and members of the committee know, in Montgomery County, we have a long history with segregated housing patterns. I grew up in a predominantly Latino community in the chair's district. My parents chose to reside there because of the affordability, because of close connection to familial ties, social connections, things like that. And so we believe that that's a highly personal choice that affordable housing providers can't be always held responsible for. There are many reasons why a family might decide to settle somewhere that does not have to do with perpetuating segregation. And for those reasons, I urge the committee to support the bill with the amendments outlined in our written testimony. Thank you.
All right, with that, that'll conclude the testimony in the hearing for Senate Bill 274. Thank you, Senator Sidnor. We'll now move on to Senate Bill 322, Senator Sidnor.
So I wanted to press that button. All right. So Senator Sidnor here to testify in support of Senate Bill 322.
Would you like your pen? Would you like your? Do you have a sponsor panel that you'd like me to call up?
Yes, thank you.
I know.
When I had first, around the time when I first came and joined the General Assembly, about a year or so after, in 2016, I had received a law review article in the Washington and Lead Law Review called Keeping Cases from Black Juries, an empirical analysis of how race, income, inequality, and regional history affect tort law. And this was written by, at the time, my former dean, of the University of Maryland School of Law. Now, why am I bringing this up? Because it has absolutely nothing to do with today's bill, except that we're talking about jury composition. Whereas the professor noted discrimination talking about civil cases in tort law, what we're here today talking about is jury disqualification on the criminal side of things. So currently, Maryland law prohibits individuals who have been convicted and sentenced to imprisonment for more than 1 year from participating in jury service. This is one of the harshest jury exclusion statutes in the nation. Maryland is one of 5 states that exclude those convicted of misdemeanors and offer no reenfranchisement except if pardoned. This disenfranchisement disproportionately affects Black Marylanders, particularly Black men. While Black residents make up 31% of Maryland's population, we've heard that 71% of the Division of Corrections inmate population is Black. Disproportionately excluding Black Marylanders from jury service not only robs those individuals of an opportunity to contribute to their community, research shows that when part of a diverse jury, all jury members deliberate more carefully and make fewer factual errors. Senate Bill 322 changes our jury exclusion statute to remedy this injustice. Instead of excluding anyone convicted of a crime punishable by more than a year in prison, Senate Bill 322 excludes anyone currently serving a sentence, whether incarcerated, on parole, or in probation, and anyone convicted of a crime like perjury, witness intimidation, jury intimidation, that hinders their ability to serve faithfully on a jury. This sound policy change aligns Maryland with the vast majority of states, maintaining the integrity of our juries, and expands the pool of potential jurors to those who should not be excluded. Jury service is a vital part of our justice system, and excluding every individual with a conviction hinders that system's ability to function effectively and legitimately. People who have had contact with the criminal legal system remain members of their communities and should not be excluded from one of our nation's most fundamental civic duties, especially one that directly affects them and which they should have the opportunity to participate once they have completed their sentences. Senate Bill 322 provides a remedy to a statutory barrier to jury service that keeps Maryland juries disproportionately homogeneous and discredits the efficiency and legitimacy of our justice system. Before I close and ask for a favorable committee report, I did want to address the testimony that was submitted by State's Attorney Richard Gibson on behalf of the Maryland State's Attorneys Association. And what I wanted to simply say, when one looks at what he's written, and is one of the second to last paragraph that caught my attention, where he says, can a victim, the defendant, or their impacted families get a fair trial when the people assembled to reach the conclusion of guilt or innocence have themselves been incarcerated for the same or similar charges as the defendant now faces? If those jurors took the position, I did my time, so should they, doesn't that impact the defendant's ability to get a fair trial? Conversely, if they took the position that no one should be exposed to the jail prison system, doesn't that impact on the state's ability to get a fair trial for the community? To that, what I will say is this. The question is, what kind of system do we want here in the state of Maryland? The state's attorneys, they have someone incarcerated. That person does do their time. They leave the system. Are we continuing? If one looks at what the state's attorneys puts forth, I would suggest that they're probably looking for a system that's not rehabilitative, but one that's more punitive. You've served your time. You've done what you were supposed to do, what the court has said that you're supposed to do, in accordance with what we have said the penalty should be. After that person serves their time in prison, they deserve their rightful place back in society, and really this, I know we'll have a few witnesses who I think are going to be testifying favorable with the amendment, which I think is great. Honestly, maybe my bill didn't go far enough. if you're thinking about that concept. But I know how we are down here, so I'm trying to take baby steps and trying to ensure that the crimes that we have not excluded are ones that kind of go towards people's truthfulness and their honesty and the like. So if they've been convicted of crimes like perjury, witness intimidation, jury intimidation, or those Title VIII crimes, bad checks, ID fraud, public fraud, and I would assume even our president would probably be prohibited from serving on a jury here. When one looks at some of these, I mean, he was convicted of false business records. But if he can serve the White House, even he deserves to serve on a jury here in Maryland. So with that, I rest and ask for a favorable committee report.
Christopher Dews, testifying on behalf of Out for Justice. I'm actually only testifying because DeJuan Burton could not testify, so I'll be very, very brief, very, very brief. Out for Justice, this is a big issue. When we surveyed our individuals, individuals who are formerly incarcerated and want to participate in jury duty, which was a surprise to us that so many people were excited to take their time and really want to participate in juries. But we took their conversations very seriously. Many of them actually, some actually do have Title VIII charges. So the only amendment that we would like to the bill is just taking that one line out, but everything else for it to stay, because those are directly related to courts. But outside of that, jury duty is very, very important. And these individuals want to participate in the process. They want to be able to affect specifically their communities and how people are sentenced. And we think that's a very important thing. And I know there are other witnesses on the panel who can talk to how this is already very common in other jurisdictions, other states, and so just going to leave it at that. Thank you all. Urged favorable with amendments.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Natasha Kaufney. I'm an attorney at the Office of the Public Defender. Maryland Office of the Public Defender respectfully requests this committee to issue a favorable report on Senate Bill 322. This bill would limit the number of individuals who are currently disenfranchised from serving on a jury in Maryland, where 1/3 of all Americans have a criminal record. This bill would allow more Marylanders to serve their community through the jury service. In particular, this bill would have a significant impact on increasing opportunities for jury representation, whereby Maryland currently leads the nation in incarcerating young Black men, such that Maryland has incarcerated the highest percentage of people who are Black in this country, more than twice the national average. The Justice Policy Institute has found more than 70% of all people in Maryland's prisons, double the national average, and almost 80% of people serving at least 10 years are Black. These are the highest rates in the country, easily eclipsing the next closest states, Mississippi, South Carolina, and Georgia. This bill changes the current law, which has a more expansive view of individuals' ineligibility for jury service because of criminal convictions. Individuals with criminal contact are still members of their community and should not be silenced or prevented from one of our country's most basic civil duties. But also, one of the individuals with criminal records are directly impacted by and should have a right to participate in after their sentence has been served. For these reasons, the Office of the Public Defender urges this committee for a favorable report on Senate Bill 322. Thank you.
Good evening, members of the committee. Heather Warnken. I serve as the Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support of SB 322. Access to a trial by a jury of one's peers is a fundamental tenet of the American legal system. Yet in Maryland, especially for Black residents accused of crimes, this is simply not a reality. The statistics on jury exclusion, as you just heard, are alarming. I'm not going to repeat them, but I do want to emphasize something, which is that Maryland takes this further than most states. In addition to having one of the highest overrepresentation of our Black residents incarcerated, We also have one of the most restrictive jury exclusion statutes in the country, being one of only a small handful of states which excludes people from jury service for both felonies and misdemeanors, punished by incarceration of a year or more. So SB 322 would remove this outdated and highly problematic barrier, allowing for greater diversity of our jury pools and the reenfranchisement of people with past convictions who have paid their debt to society. So allowing for greater participation in this important civic duty isn't just fair, it's more effective in advancing efficiency and the legitimacy of our justice system, which is demonstrated by research outlined in our written testimony. I'm going to put that more simply. Diverse juries do a better job. Since this bill was first introduced in Maryland, other states continue to rectify this serious injustice. For example, Minnesota in 2025, Utah in 2025, and Washington State in 2022 have all taken major steps forward. Most recently, Governor Murphy in New Jersey, on his way out, used his clemency power to restore the right to jury eligibility for hundreds of thousands who are excluded. We urge a favorable report.
Oh, yes. Good afternoon, Chair, Vice Chair, and members of this committee. My name is Kiana Johnson. I'm a Prince George's County resident and a community activist, and a community advocate, and the founder of Life After Release, an organization that supports individuals returning home from incarceration. I'm here today in support of SB 322 with amendments, specifically regarding the provisions that disqualify individuals from jury service based on a conviction of fraud or related crimes. I want to begin by saying that I strongly support protecting the integrity of our jury system. Crimes such as perjury, jury intimidation, witness tampering, or obstruction of justice directly undermine the fairness of the judicial proceedings and is appropriate to treat those offensive differently. My concern is that the phrase fraud or related crimes, as currently written, is overly broad and risks excluding people whose past convictions have no meaningful connection to jury honesty or the courtroom integrity. In reality, fraud is a wide legal category. It can include low-level, nonviolent offenses driven by poverty, survival, and instability, conduct that does not automatically indicate an inability to serve honestly and thoughtfully as a juror. When the law draws lines too broadly, we end up excluding people based on history rather than fitness. From lived experience and through my work, I can tell you that jury service is one of the most meaningful markers of civic restoration for our returning citizens. Being trusted to serve affirms that someone is once again a full participant of our democracy. Over-exclusion undermines the goal and weakens public trust in our justice system. For that reason, I respectfully request an amendment to this bill. Specifically, I ask the committee to strike the phrase fraud and related crime and replace it with language that limits disqualification to fraud offenses that directly implicate dishonesty in judicial proceedings. So I ask that you return that favorably with amendments. Thank you.
Good evening, Mr. Chairman, Mr. Vice Chair, members of the esteemed committee. My name is Christine Dufour. I come here representing as the immediate past president of the Maryland Criminal Defense Bar Association and a current member of our legislative committee. We want to urge a favorable report of Senate Bill 322. I want to come here and talk about jury selection. We have a voir dire process that's completely robust, especially since the courts charged us with having an expanded voir dire 6-month experimental program. In the last year and a half, I've tried serious rape, sex abuse of minors. I can tell you jury selection goes on for hours, and we ask people, have you been a victim of a crime? Have you been a witness to a crime? Would that affect your ability to serve? Why would it be any different to ask someone who's paid his debt to community, would that incarceration period affect your ability to be fair and neutral? If he says no, it ends there, he's going to be stricken for cause. If he says, sure, I can be fair and impartial, just like if someone says I might believe a police officer more than a civilian witness, it's up to the party that does not want that juror there to use and exercise peremptory, I always stumble on that word, strike. So we want to make sure this committee is fully aware that including more people who can sit and create, as my colleague said, a diverse juror experience. We can weed people who cannot be fair and impartial out through the jury selection process. We are all capable litigants when we're doing these serious trials. The judges are usually very good neutral arbiters in asking follow-up questions. I've done jury selection in court with a husher. I've done it back where there's more privacy in the jury room, where the judge goes back there and just the moving parties and the prospective juror comes. We can't change the fact that some jurors never raise their hand. That happens, and we might never know about what juror number 57 is thinking. That's up to the litigants to decide whether or not to keep them. But I believe the jury selection process will assist in any concerns that the opponents have. Thank you.
Chair, may I? Thank you. My name is Ronald Jericho. I'm testifying on behalf of the Maryland Association for Justice in support of this bill. As you know, I'm a former circuit court judge. I've been a member of the bar for over 50 years. This is basically a fundamental fairness bill. And it affects both civil and criminal trials, not only criminal activities or trials. But the importance of it is that the current law of Maryland is racially biased. As you've heard from many, I found a 2021 study that said 36% of African Americans nationally would be excluded, about 7 million people, and nationally that they comprise about 13% of the population. So there's a huge disparity, and the article also talked about that also applying to Latinx populations, even though there aren't very many statistics on it. I would just point out a couple of things and not repeat what people have said. The U.S. Supreme Court said in 1979 that a criminal defendant's right is to have jurors taken from the community. And you've heard testimony about these people who have served their time are members of the community. Maryland Court of Appeals in 1997 in the Lovell case said something similar about the exclusion of African Americans from the jury pool. And so what we're talking about here and what the state's attorney comments that I heard talk about is they're excluded from the jury pool. And you just heard from Ms. Dufour that that's what voir dire is intended to do, get them in the courtroom, be subject to voir dire during the trial. If they're biased, then that's discovered and they're excluded. If they're not biased, because of their experience, then they ought to be eligible for jury service. So we support this bill and ask for a favorable report.
Questions from the committee? Senator West.
Mr. Chair, I feel reluctant to continue to ask questions and keep everybody here late into the evening, but under the circumstances, I've got to ask a question or two here. So if under this bill, Senator Sidner, are you saying that an arsonist would be competent to sit in a prosecution for arson, that a rapist would be competent to sit in a prosecution for rape, that Jeffrey Epstein would be competent to sit in a prosecution for sex trafficking, Charles Manson would be competent to sit in a prosecution for murder? Is that what this bill permits?
What this bill permits is any citizen that is not listed and who has not committed this particular type of crime that's already excluded would be eligible. So if any of those people who you listed have committed those types of crimes, they've served their time to society, then they would be permitted to sit. And as mentioned, when voir dire comes around, it would be up to those parties to determine whether or not that person should sit for the trial.
And then the follow-on, I guess, because I'm so glad that Ms. Dufour talked about voir dire, because I was going to raise that myself. Isn't it utterly inevitable that in the situations in which the hypos that I gave, an arsonist, a rapist, Jeffrey Epstein, Charles Manson, that the state's attorney is indeed going to, no matter what the person tells the judge, that he or she can serve impartially and make a fair decision, the state's attorney inevitably is going to strike that person from the pool?
And I appreciate what the judge said, because when I go off script and I start talking and not read from my script, I say things, and I said something earlier where I said this is about criminal law. It's not. It's about civil cases and criminal cases. So in certain cases, I mean, if an arsonist could bring certain expertise to a certain trial that maybe someone who hasn't committed arson would have. So, I mean, everyone has value. Everyone sees things differently. And again, it would then be up to those attorneys to determine whether or not that person is qualified and to serve on that jury.
Okay. Thanks for your answers.
All right.
Further questions from the committee? All right, thank you very much. Thank you all very much for hanging in there with us. With that, that'll conclude the hearing for Senate Bill 322. We'll now move on to Senator Love with Senate Bill 295.
Mr. Chair, may I bring up my two witnesses? Thank you. Good evening, colleagues. I am your last bill of the evening. And since this is a reintroduction, there are just the three of us up here. So I promise, unless we get oodles of questions or urdles of questions, ba-doom-tsh. Thank you, thank you, thank you. So, Mr. Chair, Mr. Vice Chair, members of JPR, Senator Sarah Love here to present SB 295, the Stop Silencing Survivors Act. You may recall this bill from last year. This bill seeks to address an abusive litigation practice that targets survivors of sexual assault. As we've talked about multiple times in this committee, sexual assault is the most underreported crime, with only about a third of them being reported. Contrast that to robbery, where about 60% are reported. And yet, when survivors speak out about their experience, they're often sued. They're sued for a number of torts, including defamation or intentional infliction of emotional distress, and they're sued by those who have assaulted them. This tactic has the intended effect of not only further victimizing the survivors, but also dissuading other survivors from speaking out about the crime they suffered. Last year, we intentionally modeled the bill after our current law protecting employers who provide references for former employees. This year, in light of some concerns brought by members, we reduced the burden that the defendant will have to meet to dispute that the movement acted in good faith, from clear and convincing to preponderance of the evidence. So this year, the bill provides that a person acting in good faith may not be held liable for disclosing any information about allegations of sexually assaulted behavior to another person. The bill further allows that the good faith presumption may be overcome by a preponderance of the evidence that the person acted with actual malice or recklessly disclosed false information. SB 295 strikes the appropriate balance of preserving access to the courts for those who have a legitimate claim with ensuring those who bring these suits have been harmed and are not using them to further abuse their victim. I do want to answer one quick question that might come up. You all may remember that I had a bill called UPEPA, the Uniform Public Expression Protection Act. So you may ask me, would this fall under UPEPA? And to quote one of our members, maybe. But some courts have held that sexual assault is a private matter, not a matter of public concern, which is what UPEPA addresses. So with that, I respectfully request, I'm tripping over my words, a favorable report on SB 295, and I'll turn it over to my panel.
Good evening, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 295, the Stop Silencing Survivors Act. Thank you, Senator Love, for your continued leadership. So look, this is the problem. The state of Maryland encourages people to come forward and report sexual assault. And then we don't protect them from retaliatory lawsuits. And this is across the country. People across the country are filing lawsuits in an attempt to silence and intimidate survivors. There are even law firms that are devoted to finding and soliciting these cases. There, of course, are also other litigants who have valid claims. We do not want to keep them out of the court. No one, including the Maryland Coalition Against Sexual Assault, wants to shut the courthouse doors to valid claims, but we do want to correct the balance. Senate Bill 295 would both reduce the burden on survivors and keep the courthouse doors open to those harmed by false statements. We joined 6 other states which have taken that step. Current Maryland law allows perpetrators to just allege a false statement was made, and then the burden shifts to the survivors to prove that the statement was true. This means we're expecting survivors to have the experience of being sexually assaulted, listen to the many messages encouraging them to report, gather the courage to report, but first, evaluate whether they can support their statement in court by a preponderance of the evidence. Keep in mind that the majority of adults who are sexually assaulted are under 24, don't have law degrees or access to lawyers. Most sexual assaults happen in private with scant evidence available, and current law does not take into account whether a statement is made in good faith or not. Also, if they decide to report to the criminal justice system, that's protected, that's immunity. But if you're reluctant to use the criminal justice system, then your statement to your school or your friends or your employer, that is not protected. It is the nature of lawsuits. Somebody has to have the burden of proof. But it's unreasonable, it's unfair to place that burden on the person making a statement in good faith. And for those reasons, we urge a favorable report on Senate Bill 295.
Good evening, Mr. Chair, Mr. Vice Chair, members of this esteemed committee. I'm Jody Kavanaugh. I am an attorney and the director of the Sexual Assault Legal Program, Sexual Assault Legal Institute, and here in support of Senate Bill 295. The Sexual Assault Legal Institute provides direct legal services to sexual assault survivors across the state of Maryland. This includes training and outreach to colleges and campuses and holding virtual office hours for college students. I'm here to say that SB 295 addresses a very real problem in Maryland, and I'm here to give you some examples. You may remember last year testimony about a doctor in Maryland that opened a clinic in Prince George's County to provide medical services for in an underserved, economically challenged area of the county. He used his position to molest female patients. There was one woman who decided not to report her sexual assault until she saw a local prosecutor on TV asking for victims to come forward. She was one of 3 women whose cases the state's attorney's office investigated and filed charges of 4th-degree assault against that doctor. One case led to a not guilty verdict, and the 2 other cases were steadied on the condition that the doctor permanently give up his license to practice medicine. Several years later, the victim was served with a civil lawsuit alleging defamation, malicious prosecution, intentional infliction of emotional distress, and interference with contract, and other various causes of action. In another case, a student at a Maryland university was sexually assaulted off campus by another student. She reported this assault and sought help through the student judicial conduct process. The school did investigate and found that sexual assault had occurred. This survivor did not want to pursue criminal charges. She did not want to pursue criminal charges, and it was very costly for her family. She was sued as well as the school. We are asking for a favorable report. Rapists and abusers are currently using the law as a weapon to continue to control and abuse victims, dragging them into court and asking them to defend their stories and accounts of their assault in front of and for the benefit of perpetrators. These suits are also a way to extort survivors into silence by making monetary demands of hundreds of thousands, sometimes millions of dollars, in addition to the cost of defending these suits. And it's scaring them into silence. One of the biggest reasons survivors remain silent is fear of retaliation. And this gap in the current law allows for perpetrators to do just that. So we're asking for a favorable report. Thank you for your time.
Excellent, thank you very much. Seeing as though there are no questions from the committee, that will be the last. That will be the last hearing of the evening. Thank you very much, Senator Love. Thank you all very much. That'll conclude the hearing for Senate Bill 295 and the hearings for the evening.